visa has been rejected, my lord.
So what are you seeking? Quashing?
Yes, my lord.
Quashing, what urgency?
My lord, that's 337.
You have other remedies.
No other remedy.
Other remedies. You give it, we'll see. Because see, 130.
337. my lord.
So many matters.
Yes,
may not
May
be
I
possible.
mention,
We'll see. Yes.
Lordship,
Yes,
the criminal appeal 308 of 2011, Lordship said directed to be listed. I requesting for Wednesday, the first item, my lord, after bail application.
You take chance, list it on Wednesday.
Wednesday, man.
Great.
Great.
KRLC 5528 of 2023. This matter was listed on 2nd September 2024.
We'll see the urgency and list. It is not possible.
Interim order was directed to be continued, but in order said that part has been omitted.
Huh?
On that day,
I don't know what kind of interim order, who is asking time. I have to see it. It's not routine that every interim order should be continued. There must be some reason.
due to illness, Mr. Behra.
I don't know. Let it come. We'll see. Yes.
At item 34, I may be permitted to withdraw, madam.
Yes. 34 withdraw.
I may be pardoned to make a mention, Your Lordship.
1 minute. 52 withdraw. 52 withdraw.
I don't know, 108, I pray for an adjournment, your lordship.
108.
Yes, interim order is there, your lordship.
Interim order is there.
Yes.
Who is the other side?
Other side, I think someone is
No,
appearing.
don't mention. Yesterday the same complaint came. You come at the time so that we'll.
Okay. Lords,
One
yes.
matter, item 132.
Oh.
I'm aware your lordship's board is extremely heavy today. Item 100.
See, the bar demands that more bail applications should be listed. If 60, 70 bail applications are listed, then there is no question.
My
of-
lord, I don't complain on that. My lord, 132, it's a 2013 matter. 138 NI Act, proceeding of the year 2009.
Let it be there on the board. We'll see.
My lord, I was just requesting your lordship that your lordship may fix any date at 3 p.m. so that it can reach.
See, today also 2 p.m. matters are listed, 3 p.m. matters are listed. Nothing.
for standing there, my lord, stopping to lordship
It is
notice.
so impractical. You want a date, give a date according to
My
which
lord,
law.
time may be fixed so that I'll take my chance.
Oh,
because
3:30, make it 3:30.
Yes.
138 matter. You are the
130
complainant. You are the complainant.
complainant
Yes.
won in both the courts.
I know.
2013, he has not got a single pie. And that time, that amending act was not there.
That
is the problem.
143A, 148
Yes,
was not there.
Not there. Because your lordship said that it is not retrospective, it is prospective. So, my lord,
We'll see. We'll see.
Lords, I'm not praying for a,
3:30.
I'm not praying for an adjournment, lords. Only, my lords, are bringing to lordship notice. Maybe noted, my lord, 134 and 135. Both the matters listed today to be taken off specific at 2 lords. I'm bringing it to lordship notice only.
No, not possible. Let us finish up the
And maybe
Let us,
pardoned to
if lordship permits, my lord, let us start with a positive note. That release
let
there.
us see. Let us
my lord, another matter,
Yes.
113.
one day, one matter.
No,
Tomorrow, we come tomorrow.
I'm
Yes.
seeking an adjournment, not
Adjournment, okay. Adjournment very easily. Yes.
113. Any date suiting to your lordship?
He will, don't pressurize him because
No,
he
no.
adjusting.
My lord, I'm the last person to do that.
Okay, he'll do it. Yes.
Interim order
Yes,
can be
interim-
extended. my
interim
lord.
order.
My lord, 128. And it taken up after lunch.
He
128.
come after lunch.
I'm permitted to make mention, my lord. Item
It is
7, my lord.
compromise matter. Compromise matter. Parties are coming.
The parties have come, then bring them at 2 o'clock.
2 o'clock.
Permitted to make mention, my lord. Today list item 7, my lord. Kindly taken up next week, my lord.
Adjourn.
Obliged.
Requested. Yes.
I have pardon to mention, Your Lordship. I understand, my lord. I'm well aware your lordships are under tremendous pressure. My lord, I'm only praying, my lord. It's been in your weekly list, my lord, for a while. I was only hoping, my lord, it can stay in the weekly list, or if your lordship can
Let
put
it be there in the weekly list. The day when I'm free, then I can take it up.
My lord, I was, my lord, hoping only if your lordship's consideration, my lord, any day if it can be on a supplementary list, last matter in a hearing matter, last matter, any day, my lord, if it can be.
Which year matter is
My lord, 2006, my lord. It's everything is ready. My friend is also ready, my lord. In the
that? Are
vigilance.
you ready?
No, my lord, in the vigilance, I have mentioned, informed him. He also knew.
If both of you can mention, I'll shift. Otherwise, unnecessary burdening.
I'll make a mention.
You bring him
Yes, your
so
lord.
that I can
Any day at the last
put
year.
it at the end of the.
Yes, my lord. That is what I was praying. I'll do so, my lord.
What
Great.
is appeal matter? Is it appeal matter?
Vigilance, my lord.
Is it appeal matter?
Yes, appeal.
You bring whoever is
Yes,
appearing.
sir.
Both of you can mention, I'll put it. at the
I'll do
last
so,
of
my
the year.
I'll do so. Great.
Yes, sir.
Item 4, my lord. Compromise matter at 2 p.m.
2 p.m. Compromise. Yes. Yes, online.
pardon to make a mention, Your Lordship. Today's list, item 75, I want to withdraw, Your Lordship.
Withdraw, 75 withdraw, yes.
Best. My lord, item 190.
190.
190.
119.
I seek for adjournment, my lord.
Urgent at the record, yes. Yes, start.
Item one. Item one, my lord, in the meantime, matter has been compromised, my lord, parties are found.
Parties are there.
Yes,
What is the offense?
offense, my lord, 447, 341, 354, 323, 294, 506, and
Just see,
But that is the police report also come, my lord.
huh?
She wants to compromise the matter.
Compromise, right?
That's it.
That's why I am appealing for the.
1 minute, 1 minute. Was there any direction to that effect?
My lord, my lord. My lord, direction, my lord, 10/11/2022, my lord, to the State Council after instruction of whether the matter has been compromised through police, my lord. Police, my lord, given instruction 4/11/22, 4/12/22, stating that the now resident of Bhunsar such and such, she stated that she wants to compromise the case without pressure, without any
Yes,
threat.
right on.
She is
The petitioner, at the instance of opposite party number 2, the FIR number so and so came to be registered against the petitioner. Petitioners have invoked the inherent jurisdiction of this court under 482 CRPC, seeking passing for the entire proceeding on the basis of settlement. The matter was taken up on 7/12/2022, and the coordinate bench of this court has passed the following order. Who is opposite party number 2?
Yes.
Sasmita Mahanti. Madam, settle कर देले आपण. हाँ?
Settle कर देले एकदम.
Settle हिला. कौन हला settle? अच्छा ठीक है. And accused, who all are the accused? Who all are? There are 5 accused, 4 accused.
No. Petitioner 1 is present.
Why the other 2, 3 are not there?
Bharat Bhushan, Ajay.
Are they VIPs? Accused will not come behind their back, it will be quashed. What is this practice? You should have advised all the accused to be there. I don't know if some accused is doing some crime today, somewhere at this time.
That has happened.
What will happen?
You are in custody. That
What will happen? Suppose he today is just now is committing a crime. I will quash.
One case you will not see.
And he'll take a plea of alibi.
One case, my lord, the accused in custody was here.
Yes,
But thereafter,
one case the same thing happened. He is in custody. He said that I have settled the dispute and I quashed it. Subsequently, I discovered that he is in custody. Whether these people are alive or not, I don't know.
Virtual appear करते दिटालु virtual appear करते रहे अन्य माने भुवन सर कर देवे virtual
दुईटा को बाकी जगह रखंतु मैडम को फ्री कर देंगे मैडम should not come.
नहीं भद्र appear कर देवे
Then I'll quash the petitioner one. I'll quash the petitioner number 1 and let them suffer.
Let it come on another day.
No. Why is that lady will come unnecessary? Because of your mistake? The opposite party number 2 and the petitioner number 1. Kamalakant Roy, petitioner number 1 are present in the court. Petitioner number 2, 3, and 4 are not present today. The petitioner number 1 and opposite party number 2 are represented by the respective counsel and identified with them. They will also file self-attested copies of their evidence. A self-attested copy of their Aadhaar card, which is taken on record. The opposite party number 2 has also filed an affidavit dated 20th October 2022. Wherein she has stated that she has already settled the dispute with the petitioners, and she doesn't want to proceed against the petitioner anymore. This fact it has also been verified by the IIC Vasudevpur and placed a report which is reflecting from the earlier order. of this court, earlier notice, taking into consideration the aforementioned, I'm inclined to quash the present FIR, qua the petitioner who is present in the court, at this stage, the counsel for the petitioners submits that one more opportunity shall be given for the presence of the other three accused persons, In that view of the matter, release the matter on Monday, coming Monday. Tuesday, and the petitioner number 1 and opposite party number 2 may not appear on the next Tuesday, first morning. Please. Okay. Bring them. It is better for you also, I tell you. Don't advise your client not to come. Many a time what happens, the lawyers are advising. You need not come, I will manage it.
Yes.
And it is so dangerous for the lawyers also. Tomorrow they'll turn around and make allegation against you. Don't even do that. Call them Tuesday, and insofar as these two people are concerned, they may not come. I'll pass on that. Okay. Yes. Yes, madam.
Petitioner is asking the order dated
Opposite party number 2, service.
has come, he has appeared. Someone has appeared already, Your Lordships.
No, last time the notice was.
Lordships.
Durga, the Lalit Narayan Patnaik has already appeared.
Already paid. Okay. Yes, madam.
Lordships. I'm assailing the order of cognizance, Your Lordships.
Hmm.
The initial FIR was lodged against another person whose name is Gunduri. He was the milkman. And the offense was under section 380 IPC. The fact is that the informant and the present petitioners were neighbors, and the milkman had left the milk for the day for the complainant in the house of the present petitioner. When she went and left, gave back the milk, after some time he realized that his house has been burgled. Now the question,
In the pretext of giving the milk, you have done it. That's what the allegation.
That is the latest stage, latest story. The initial FIR was lodged. It was lodged against the milkman. The FIR was lodged on 8/12/2018.
Okay.
It was against the milkman, saying that the milkman had done it and other. The first 161 statement was also on 8/12/2008, pointing towards the milkman. And that he said that he has done everything. A year later, that is on 8/7/2019, a second set of 161s were recorded, wherein the blame was pointed towards me. Saying that
Charge sheet is filed.
charge sheet file. Saying that it was
Happened this case, my lord. For that is in
So nobody will help the neighbor to keep the milk.
the keys.
that is
I was having the keys of
380 only.
issue notice to the opposite party as because my lord, there will be compromise, my lord.
Yes.
But in fact, for somebody appear, my lord,
Hmm.
whether the matter has been compromised, that
What have you taken from their house?
nothing.
my lord,
What is the allegation?
Allegation is that some 2 chains, 2 bangles, and 2 something.
Recovered from you?
No.
Then
No
what
recovered.
is
in this
that?
case, actually, my lord, what happened?
Hmm.
The accused and also the informant, my lord, they are front door neighbors, my lord.
That is
Whenever the son and the wife and the informant went to their workplace and school, my lord, by the time they always keep their keys with the accused.
No, he was helping.
My lord,
And
on
now
the
you are.
particular day, on the particular day, when the milkman came to the house of the
I will
informant,
send to mediation, otherwise I'll
my
quash
lord,
it.
district medicine house.
I'll quash it. I'll send it to mediation.
Lordships.
What is this? The neighbor, he was trying to help you, keeping your children in his house and the key.
There is another
And
case.
he, the milk also he kept, and he went to deliver. And
And I didn't drink it also. I diligently gave it
Better
to
you should have drank it.
Now I repent.
Somebody appear, my lord.
Anyway, notice was issued to the
Lordships.
party number 2.
Notice already, sir.
Opposite party number 2. Although so and so, who has entered appearance?
Lalit Narayan Patnaik, DC Das,
Mr.
and
Lalit
Maharaj.
Narayan Patnaik and Durga Charan Das entered into appearance, but none appears on their behalf today. From the allegation, it is found that the dispute is regarding the allegation of theft against the petitioner. Petitioner is a neighbor of the opposite party number 2 informant. Informant. It is alleged that the milkman had left the milk in the house of the petitioner in the absence of the opposite parties. In the pretext of delivering the milk, the petitioner had committed the theft. Since the petitioner and opposite party number 2 are neighbors, the allegations are very minor in nature. It would be appropriate that the petitioner, the opposite party.
I'm a land partner for information.
Yes. Why don't you settle? What is this? He is your neighbor.
Pardon me?
He is your neighbor. Why don't you settle the dispute? I am sending it to mediation.
No, my lord, what happened? They are not ready to set up the matter. And there was a.
You tell either you settle or I will quash.
जाओ mediation जाओ.
Simply, I am sending it to mediation. You tell them.
Just she's behind me, my lord.
No, there is something. I am sending it to mediation.
Will your lords be kind enough to hear me
Yes.
some moment? No, what happened, my lord, is the neighbor, admittedly is the neighbor. But it doesn't matter, he will steal the articles, the golden.
How do you know you have made allegation against the milkman first?
No,
After 6 months, you say that no.
That is not the affair. Affair is doubt on the persuasion of the lady. That the accused told that the milkman had come.
The
He might
police
have-
investigated, nothing is recovered from there out.
My lord, yes, polygraph test is there. After all the trials became polygraph tested, and after that, both the accused person has been charged and the milkman has been discharged. That is the fact. Polygraph
Anyway,
test
you
is-
try. I am sending it otherwise. See.
My lord,
Mediation, I am sending to mediation.
Mediation जाओ.
Try.
Lord, there is matter is posted for charge. Charge me.
Appropriate to send it to mediation. See what to do. Interim arrangement made on 27/8/2024 shall continue till the mediation report is placed on. Yes.
High Court mediation.
High Court mediation. Yes. Three.
May I please, Your Lordship?
Yes, sir.
But prayer to decrease the bank account. This is the second round of litigation of the petitioner's matter.
Defreeze of bank account.
Decrease of bank account. My lord.
Okay.
Earlier, my lord, the petitioner has approached this honorable court by filing a CRLNC, which has withdrawn, my lord, with a liberty to approach the revisional forum. And the revision was filed before.
And now it is rejected.
Now it is rejected, my lord. Here, my lord, case is that several affairs are lodged with different agency, my lord, for selling spurious drugs, my lord. That is Telma 40 and Telma AM, my lord. So
Notice has been issued.
No, state, my lord, state.
Huh?
here, my lord, it is
Here.
state, my lord.
State.
But
What
the-
happened in this case, my lord?
Huh.
The trial court as well as the revisional court dismissed the petition about both the petition since, my lord, there investigation was going on by the time, my lord.
Now investigation is over.
But that is not, I have not taken.
Yes, investigation is over, my lord. Charge has been filed. Just.
At the stage of investigation, all these things have happened.
That is rejected.
When the revisional order was passed, my lord, by that time, my lord, charge sheet was filed.
Investigation going on.
Where is that? Where is that impunity?
My lord, your lordship, kindly say Annexure 8, my lord. I have given one judgment of this honorable court, my lord.
That no.
Past
Tell
in
me
CR
the impunity. Show me.
Impugned order, my lord, at page, the relevant portion is at page 30, 233. my lord.
Point number 8.3, my lord. Page 32.
Yes. Investigation is going on.
My lord.
Let's see.
At
At that stage, it has been done.
That observation is not sent.
I'll record everything and record that judgment also. I'll send you.
Just a minute, kindly hear me, my lord. If your lordship will, my lord, send me to the revisional court, my lord, again I will approach. Two CRLNC was filed, my lord. By this farm, my lord, one CRLNC, by another farm, my lord, another CRLNC for defreezing of the account, my lord. That in another case, my lord, this honorable court has already given a direction to defreeze the account, my lord. That order, my lord, I have annexed, my lord, by Annexure 8.
Annexure 8, I know that. I've seen.
So, my lord, I pray for your lordship, my lord, to kindly, my lord, direct my lord and friend, my lord, check, my lord, check that judgment. If at all, my lord, I am coming with that judgment, my lord, I don't have anything. This is option Annexure 8. For the self-same matter, my lord.
Okay, let Mr. Raghunath, land counsel for the petitioner, needs to examine the judgment cited by the petitioner in the present case And address the court on the next date of hearing, release the matter. Yes. Next.
But annexure 8.
Four. Four. Okay, fine. Fine. Here, wait, please, my lord. Okay, it has to be urgent because Maharana, yes. You are there. Yes.
May I please, madam? Lord, the petitioner is facing a criminal prosecution for criminal misconduct in aid of section 107 of the IPC, madam. Where the principal accused, my husband, is no longer there. And he was charged for having disproportionate assets to the known source of income. All that the allegation against me is concerned that I have abetted, a bold statement has been made.
Yes.
Without
The in the absence of
how I can
accused.
account.
1 minute, I understood.
Yes, my lord. How I can account.
In the absence of the principal accused who has died, under the aid of 107, you have done it. 109 you have implicated. How will you?
So far
proceed? How will you secure it?
She has independent defense. Number one, so your lordship's judgment will not cover. Then another, so far the other party is concerned whether at the date of principal accused, the 109 wife against salary referring to the Supreme Court judgment, this honorable court has categorically says that. I'm relevant person, I'm not. The sole public servant died, and under such circumstances, the apex court concluded that since special judge has also exercised his power under section 4(3) of the PC Act, he cannot be divested of the jurisdiction of proceed against the non-public servant, even if the sole public servant dies, in as much as the charge against the public servant alone abates. Then, relevant point I am placing. The court is of the considered view that the prosecution is based on the allegation of corruption and acquisition of disproportionate assets by the principal accused and the petitioners. Being the abettors, and on the death of the principal accused, the jurisdiction of the special court is not divested. The very foundation of charge is the petitioner abated the principal accused. So, trial will continue. Then another relevant part. Referring to the Supreme Court judgment Jitendra Singh's case, it is held that even though charge is not framed, the London court below is not divested of jurisdiction to proceed with the trial vis-a-vis the petitioners. He was the abettor there. Same case, DA case. Then relevant portion, another, that my lord has held that having gone through the charge sheet, the court finds that detailed inquiry has been made and petitioner number 1, which revealed the criminal misconduct on the part of the principal accused.
There's a case of 109.
109. And the former having had no independent sources to begin with the business and also to become a super class contractor. So their wife was also there, son and wife. The license
in this case, do you have a separate defense?
I'm just a housewife, my lord.
But show me, what is this difference?
The facts and circumstances of that case, I need to go through that. But your lordship,
No, if you have a separate defense, then insofar as your defense is concerned, you have to.
He was filing income tax returns, showing business income.
My lord, during the check period, they have not said that I was filing any income tax returns, my lord.
Then defense.
The allegation against me is that certain properties, my lord, I'm squarely covered by your lordship's judgment.
No.
In the case of
No.
Sonalata.
I know
Then
that,
the lordship
but
has said,
that's
since I'm in a
just,
domain.
no, you are not covered. Because if you have a separate defense you set up, then you have to prove that.
I don't have any separate defense, my lord. Let me go through the judgment which my learned friend is citing.
I was conducting that. Case.
Yes, give it.
And E. Sonalata case na put in
Judgment to
you got the citation.
examine the judgment cited by Mr. Maharana at the bar. Which is that judgment?
Number of Nalinikanta Muduli and others versus State Odisha Vigilance Department, CRLMC 1959 of 2022. And another judgment of Delhi High Court and division bench of this
judgment is directly against.
Directly Supreme Court judgment. CRLMC 1959 of 2022.
Of 20.
22.
22.
Item 6.
Lordship may call it next week, my lord.
Next week.
I really go to complaint case. 138 NI Act, my lord.
138 NI Act?
Yes, my lord.
Notice issued?
No. Let
You are
notice go, my
complaining or
lord.
accused?
I am for the accused, my lord. Let notice go, let him appear. The matter may
How
be
are you,
settled
how are you
here.
agreed and by what you have?
In the year 2012, my lord, occurrence was taken place. He was placed the checks thereafter, after 4 to 5 years after. The land is in dispute, my lord. He is the tabler of the land.
How,
He has
you are agreed by what?
agreed by the cognizance was taken, my lord, in the year 2018, my lord.
2018
my
cognizance,
lord.
today you are challenging in a 138 matter.
Yes, my lord.
Where the
Now,
statute says 6 months. Statute
let-
says it has to be concluded within 6 months. You are
Still
challenging
pending,
the
my lord.
cognizance order after.
Nay. Now the case is still pending, my lord. Let notice go, both will appeal.
No, no.
That
You
may
satisfied?
be,
No, no.
that may
Unnecessary
be
burden on
filed
this.
here, my lord, settle here, my lord,
No, no.
or sent to mediation.
No, you just satisfy me that the cognizance order taken in 2018, 5/5/2018, you are
Yes, sir.
challenging today in a 138 matter where the statute,
As per my instruction, my lord. That is there, my lord. That was still pending, my lord.
May be pending. You should have come, or whatever.
Let notice go, my lord.
No. Unnecessary, we are pending, as it is, we are overburdened. Right, you withdraw to raise all the point before that. Let the counsel for the solicitor seeks to withdraw this present petition to raise all the points as has been raised in the present petition before the trial court. He urges those points. The trial court is expected to deal with all the containing conditions raised at the appropriate stage. With this liberty, the petition is disposed. Yes.
Obliged.
Yes.
Yes, sir. I'm filing this LMC to quashing the cognizance by virtue of the compromise.
Complete. Opposite party number 2.
So he has
Notice
appeared.
by the-
The opposite part number 2.
You are appearing?
Yes.
She is appearing. Okay. Yes, sir.
The matter has been settled between the parties.
Have you settled, madam?
Yes.
What is the offense?
Offense law 341, 294, 323, 506, and 34.
Okay, you see. File affidavit, joint affidavit.
Yes, Lord. He already filed affidavit.
Not joint affidavit. I am my.
The informant filed the affidavit.
Call them.
Yes, Lord.
There is all a copy, madam, that affidavit.
So and so entered appearance on behalf of party number 2. Both the counsel appearing for the parties conjointly request for an adjournment on the ground that the parties have settled the dispute and the parties will be appearing before the court on the next date of hearing, least the matter of 1 week after. Yes. Settle matter, got this. Yes.
Item 9.
Thank you.
Item 9, kindly pass over.
Today don't ask for passover, sir. Adjourn karo. Passover.
My lord, earlier also
may not
it was
reach.
urgent. My lord, the cognizance was taken in 2010.
Alright, cognizance is taken.
And my lord,
you
earlier
are coming today.
And earlier, my lord, also 2 CRM issue was filed. One was disposed of on 14/10/22 to raise the all plea at the appropriate stage. This is the order that.
Why are you filing these kind of petitions? Earlier, what was the file?
My lord, kindly see that order of CRLMC number 1663 of 15.
Do you have that order? Give me.
Order I have downloaded, my lord, from the copy. Is not there.
CRLMC?
My lord, lordship, it will be available in lordship board, my lord. CRLMC 1663 of 2015.
They have given declaration.
Yes, my lord, they have given. 2015.
CRLMC 1663 of 2015.
15. Disposed of on 14/10/22.
It काढ़ी रखी तो pass over कर dismiss कर दो. I'll dismiss it. You call in your presence. I don't want to do it. Pass over करो. Without dismiss. Yes.
Item 10.
May I please your matters?
Yes, sir.
Last topic is to clarify whether the NBW has issued against the present petitioner and I am not filed, my lord, and my lord directed to take instruction whether the NBW has issued and to show the documents, my lords. And that is the NBW.
Last date of hearing, you said that you would be filing additional document.
My lords,
Because you are challenging.
my lord.
See, because you are challenging.
6/5/2024, my lord. This is the certificate. Last page, my lord.
Have you filed it or not?
Now, just now, sir. NBW is issued, my lords.
What is this order? 28 to 2023 order?
Page 14, Lordship, 10,000 to pay for each and every month. Page 14.
10,000 maintenance.
Yes.
My lords.
What do you want exactly? You tell me.
My lord, NBW is issued against the
I'll
president.
cancel the NVDA to go and appear.
Yes.
Last page, my lord.
Although the petitioner had challenged the order dated to 28 to 2023, passed by the JMFC Cognizance 3, Bhubaneswar, directing the petitioner to pay rupees 10,000 as maintenance to the opposite party.
2-3.
But the opposite party, but the land council for the petitioner submits that the High Court submit that he would where is it? He would urge or he would argue all the points before the court below. The only impediment he points out that on 6/5/2024, the trial court has issued NBW against his client. Therefore, he seeks indulgence of this court. On instruction, he submits that his client would appear before the court on or before 25th of September 2024 and avail remedy under law. Avail under law. Regarding head to the aforementioned, the order dated 6/5/2024 passed by JMFC 2 Bhubaneswar in
JMFC LR, my lord, said. LR, my lord, not 2, my lords.
Three in CRP number 156 of 2022 shall remain state till 25th of this month, and the petitioner is directed to appear before the court and avail remedy as per law. Yes.
And I have to release. Item 11.
May I please, my lord? The case has been filed for quashing of the GR case number 1360 of 23 on the basis of Rajkanika PS case 586 on the ground that the matter has been amicably settled and the misappropriated money has been given to the complainant.
Got it. Who are they? Are they present?
Yes, my lord.
Who is Subham Rai? Okay. Who is what is this? BM, People's Forum for Finance.
Borun.
Huh?
Branch manager of that.
Branch manager of People's Forum for Financial Company of Chandavali, established under DPC Bank. What kind of bank, financial institution is this?
Microfinance.
All are
These are microfinance.
fraud companies. Who is he? BM. Na kono? BM ର full form kono? Ko bank ro? ତମେ bank employee ନା ତମେ elected?
Agent lords.
तुमको appoint किए कला? तुमको BM करके appoint किए कला? full form माने कौन? गुड़े association ना कौन है क्या? What is this people form?
Yes.
They have stated that the FIR also stated that manager of BM.
That's right, but for my knowledge, I want to know what is this people forum bank. I don't know.
I was also
whether it is a group of people have created that bank. What is this?
I was asking that question to him just a while ago, whether you are under RBI or not.
Are they guarded by RBI guidelines?
RBI guidelines microfinance.
Lordship, it is a microfinance company. Microfinance company is guided by the RBI, but not that they are. Then microfinance company, they have the some surety before the
What is
RBI
the
and
allegation?
they are continuing.
Allegation hochi 1,05,000.
He has taken loan.
Na na, he is the employee of that forum.
They are collecting the amount and depositing.
Collect କରିବାକୁ ଯାଇଥିଲା, subsequently ପଇସା ଆଣି 5 ଦିନରେ ଫେରେଇ ନେଇ company ପାଖରେ, so they have lost the affair.
ପଇସା वापस କରିଦେଲାଣି। ଚାକିରି କରୁଛି ନା ଛାଡ଼ିଦେଲାଣି? ଏବେ କଣ ଚାକିରି କରିବ ନା କାଢିଦେବ ତାକୁ? ବର୍ତ୍ତମାନ ରଖିବ ନା ନାଇଁ? ସେ ପଇସା ଦେଇଦେଲା, ଚାକିରି ତ କାଢିଦେଲ, ଆଉ ଦବନି? He is happy. Ask the young boy, for any reason he might have done it. Why should you take away his job? Huh? ଚାକିରି କରିବା ଦରକାର ନାହିଁ, କରିବନି ସେ ବ୍ୟାଙ୍କରେ, ଆଉ କୋଉଠି କରିବ? ବାହାରେ କୋଉଠି କରିବ? At the instance of opposite party number 2, the People's Forum for Finance Company, the FIR number so and so against the petitioner has been came to the registration petition. The allegation is so and so. The opposite party number 2 informed back is being represented by the branch manager, Mr. Borun Pori. Mr. Borun Pori. He is present in the court today. The petitioner is also present in person. Both of them are represented by their respective counsel and identified by them. They have also filed self-attested copies of their Aadhaar card to establish their identity, which is taken. The allegation against the petitioner is shown. The opposite party number 2, who is present in the court, affidavit filed physically, submits that the bank has already received the defrauded amount of rupees
1,05,000.
1,05,790. 1,05,790.
That in form of draft, and a copy of the draft is also
The bank has received the same from the petitioner. Bank draft bearing number. After having received the entire defrauded amount, the bank is no more left aggrieved. Therefore, they don't want to proceed against the petitioner. Hence, the present petition. Hence, the petition regarding head to the aforementioned. Since the parties have settled their dispute, and the case of the petitioner is covered by the Gyansing, so subjecting the petitioner to rigors of the trial will be a futile exercise. Therefore, I incline to quash the petition. Accordingly, so and so is quashed. Yes.
Item 12.
Madam Procedural, my lord. In this application, the petitioner seek for quashing of criminal proceeding, my lord.
Yes.
On the ground of compromise, my lord.
Compromise.
My lord.
What
The
is the
victim
offense?
has already married to the principal accused, and he has faced
Where are they?
They
Where
are
are they?
My lord, I am not the
Yeah.
informant.
I understand. Where are they?
No, my lord, they have not happened.
You know, for quashing, you need to be call
Ma'am.
them. Why
So
are you
let's-
not calling unnecessary, wasting time, court's time?
Page
Leave
20.
it after 2 weeks.
Page 20.
Madam, put upon 12 fixed date.
I'm not on the basis of the mercy of you people.
No,
Once
madam.
you will come here, second time invitation will be printed for you, and invitation will be given to you. You know the pressure.
My
See,
lord.
Principal brought them.
Lordship, principal accuses the order of Lordship, page 23.
I quashed it, I know
Yes,
that, but
yes.
at least they should be there complaint. I don't know what is it. 2 o'clock?
No, my lord.
2 o'clock today.
No, my
Video-
12,
video-
next week 12, 12 तारीख.
Rahul
Give a date here. Give a date.
Rahul.
My lord, they are residing in Rahul Kela.
Huh?
They are residing in Rahul Kela. For which
So online, I am saying online. Let him appear. I don't know.
Online कर दे तू.
How can I quash in absence here?
Next week 12 तारीख.
Yes, next.
13.
That is how these people waste the time of the court. Yes.
This is another revision application.
Yes.
13.
1-3. 1-3.
1 3. Yours is 1 4.
1 4.
So 13 millards pertains to an revision application challenging an order rejecting the decision application in a trap case. But in this case, he has taken the main grounds. If Lordship can turn to page 10 of the petition and paragraph, and the ground number 3 is that he was also the same allegation. The inquiry was conducted and he was let off. And my lord,
Departmental inquiry.
similar matters is coming on 23rd.
23rd, same departmental inquiry exonerated whether, yes.
Yeah, and my lord, the petitioner for lordship is the RI lords. The main accused is the peon. The decoy's father purchased the land, went to the sub-register, asked him to give the pattas, or the sub-register asked the RI to ascertain whether there any land standing over that purchased land or not. Then RI lords asked the peon to call to demand the money. The peon was provided with the 3,000 rupees bribe amounts, and thereafter he got the money and kept the on the table
initiated and exonerated.
The main ground they have taken espouse is paragraph 8 of the grounds that because of same allegation he was let off in the department.
Similar matters are there. 23rd. Yes, 14 also same.
No, 14 ma'am.
Yes.
And I am challenging the order dated me lot 28/6/24 against 220.
Similar issue. The matter pertaining to similar issue is listed on 23rd. List the matter. Yes.
My lord, I am challenging the order against 227 CRPC. My lord, in the impugned order, page 35, your lordship has a glance, my lord. In law and trial court and observed that, my lord, admittedly the petitioner one of the beneficiary and got selected as CPI for the IRB upper column.
Page 35.
Man.
Page 35, my lord, that's the operating portion of the impugned orders. My learned friend is placing that one. Page 35 of the brief notes. In fact, he is now continuing as a constable. They got the job under the OSAP, what's a state armed police force. But the material against him, lords, you can turn to page 35, lord. No certificate, that's sports certificates.
Neither produced nor possessed any such certificate, my lord, interviewed. The only allegation against it got appointed influencing the members of the interview board. Nothing.
Which part of it?
35, my lord, running page.
You have 35, 18. Not paginated anything
yes, my lord.
On the paper on the.
Yes, my lord, I have paginated.
Where is that? Nothing. 35. It is only 18 pages.
Running page.
Lordship, no, the last paragraph. Huh? Last paragraph of the input order.
Running page, you tell me at least. No pagination.
18 of the impugned order.
Where is the main? There is no pagination here.
My lord, I have.
You might have done it for your.
Yes, two.
Not for the.
Yes, my lord, I have given to one Xerox copy and another in certified copy. Certified copy I have not paginated and Xerox copy
I'm not
paginated.
telling you lie. Just see the file. There is no.
That's my lord, sir.
You might have done it for your convenience, but not for the convenience of the.
Oh,
anyway, come to internal page. Which page internal?
18 of the impugned order.
Okay, 18. Read it now. Admittedly, the petitioner is one of the beneficiaries.
Beneficiary and got selected as CPI for the IRB for collab. And
from the charge sheet that the petitioner is working as the constable from in the end collab. In the case of the prosecution is that without producing any court certificate, the present technical persons along with the other got appointed by the influencing the member of the entry board. Yes.
My lord, thereafter.
The case is coming for the first time. Let me take some.
No, if you they have not produced any fact certificate or anything. They have influence. What kind of influence? And if they have influenced the board, selection board, whether the selection board people are accused?
Nine accused persons, sir.
No, selection.
Total accused.
Accused 32 out of 32.
That's the.
I've received a copy, my lord.
Give a copy.
My lord.
And please paginated it. Issue notice returnable within 2 weeks. So Das to seek instructions in the present matter. Mr. For the petitioner has pointed out that the only allegation against the petitioner is that he has been employed as a constable in the Indian Reserve Battalion Oporkala Koraput by influencing the selection board, particularly selection board However, he has not produced any certificate, fake certificate or fake certificate in the
Sports.
Neither produced
fake
nor purchased.
certificates regarding the sports quota on the basis of which he has been appointed. He has been appointed. Mr. Das to the instructions, please demand.
My lord, the trial court have fixed for matter for 11th.
Let the counsel for the petitioner seek praise the
Adjournments.
let the counsel for the petitioner submit that he would move application before the trial court taking adjournment owing to the fact that the matter is subject before this court. Yes. 13 you are talking about.
My lord.
13 actually I'll tell you on 23rd I have kept all the similar matters.
My lord, but on 12th, my lord, it is posted for frame.
13 like the same last he will move application. Take it up.
My lord.
I have written that similar cases coming up.
In fact, in his absence, my lord, I place that particular grounds you have taken.
The
that in
ground
same
that he
convention
has
you are
been
let off in that.
exonerated. Ground that he has been exonerated from departmental proceeding. Whether he should be proceeded or not, because Minakatan judgment is there.
Yes.
And Radheshyam judgment also you are
Yes.
all these things I am considering in a way happened.
But 12th, my lord, the adjournment.
Yes, you will move that up. Likhi do, tero re. Yes.
Deeply, urgent certificate. Deeply.
Yes. Yes.
Item 15.
Yes, sir, 15.
15, my lord, co-accused has already been released by my lord. This is arising out of a complaint case, a protest petition, where the CBI CD has given the clean sheet. Thereafter, they have initiated the case and
What is the role of this man?
He was not named in the FIR, but later on, they said that it is extrajudicial confession.
What happened in this case, my lord? Actually, earlier case, my lord, the opposite party entered their appearance, my lord. Protest petition, my lord. Though he has made the party the complaint, my lord.
Notice
here.
Notice to opposite.
Already appear କରିଛନ୍ତି ଏଥିରେ ବି
already.
No, not appear.
Issue notice to opposite party. 1 week after, just 1 week after. Let us complete the formality. Yes. 16. Yes. Not interested, huh? What is the offense?
16. 50 cents both case. Both case, my lord.
15, 16. Both, huh? Notice, huh? Notice.
17.
My lord, this honorable court by order dated 2/9/2024. Just the 2/9/2024. My lord. Now the accused is in custody since 3/8/2022.
What have I said in that?
In that case, in that order, your lordship has directed.
He said minor son was not made in
What happened in this case, my lord? Thereafter, the IO, my lord,
Preliminary charge sheet was that he was not added that vital witnesses are PW, charge sheet witness. Subsequently, it was made prayer before the court below to delete the name of the deceased as prosecution witness number 1 and insert that the son.
To me.
My lord, that is the instruction.
When the final charge sheet was filed?
Charge sheet and one deposition copy I have already filed.
Preliminary charge sheet was filed under section 302/201, my lord.
201.
301. What happened, my lord? That he is the husband.
When final charge sheet was filed?
I don't know, my lord. That there is a preliminary charge sheet was filed.
Say preliminary charge sheet.
When have you said that application you moved before court?
My lord, that is the instruction I have obtained as per your lordship's direction.
Date, so I'll.
My lord, that is on date, my lord, on 1/12/22.
1/12/22.
Preliminary charge sheet was filed.
No. When that application you moved before court, deleting the deceased name from the list of witnesses.
My lord, that is on 12/12/22. 12/12/22.
Yes. Yes, sir.
My lord. Man, in this case, your lordship, there is an allegation.
You are in custody since?
Since 3/8/2022. 3/8/2022.
What is the case?
My lord, trial is going on, my lord.
Going on, what is this? How many witnesses?
One witness examined, my lord. The
Yes,
fact
yeah.
that-
This boy was examined.
Boy was not in.
Boy has not been examined, my lord.
Examined.
Examination, after examination, my lord.
And it's a brutal murder, my lord.
I inquiring about that and
My lord.
got it. And 12-22, they have corrected that. That is a typo.
The one witness who has been examined, he is the main witness upon which the prosecution relies. He is the person who has led to discovery.
Actually,
Now he has,
Minor is the eyewitness.
he has completely turned hostile,
But minor is the eyewitness.
my lord.
on the
That is
particular day
there.
the minor was present. The father had taken him to another place, locked him, and thereafter committed crime and open and stated I had committed the crime.
That, my lord, I have
The,
submitted.
The son of the deceased, who is stated to be a
Mangaraj Naik.
eyewitness, has been examined. Has been a statement of statement under section 164 CRPC was recorded. Then counsel, Mr. Mishra, and counsel for the petitioner submits that surprisingly the said minor son of the petitioner was not cited as a witness. Rather the accused name is found mentioned.
Deceased name.
Deceased name is.
Deceased name is found mentioned in the preliminary charge. To that instruction was sought from the state council, and then council for the state submits that on 12/12/2022, the prosecution has moved the application before the trial court for correction of the typographical error which had taken place in the preliminary charge sheet, and the son of the petitioner has been included as a witness.
Charge sheet witness.
My lord, 1/12/22 is the date when charge sheet has been submitted.
No. 1/2/2022 and 12/12/2022. Since the son of the petitioner, whose statement under section 164 CRPC has been recorded, and he is alleged to be the eyewitness to the occurrence. I'm not inclined to admit the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew the bail plea after the recording of the evidence of the minor son, who is the eyewitness to the occurrence. With this liberty, the petitioner is disposed of.
My lord, obliged.
Yes. Yes.
May I please your question?
Yes, sir.
My lord, petitioner is custody, my lord. Since my lord 12/5/2023, my lord.
12/5/23.
My lord.
Yes.
My lord, for the offense under section 376(2)(n).
Yes.
Read with the, my lord, 6 of postgrad, my lord.
Yes. 164. Read it. Read one.
Petitioner is, my lord, physically handicapped under Annex 7. And the present infrared has a large thrice affair, my lord. This is the second allegation, my lord. This is the second allegation, my lord.
Earlier also there were FIR against you.
No, another person, my lord.
Where is that?
My lord, I have not.
164,
copy,
just
my lord.
point out.
He has admitted in his 161 statement.
Though he has filed some documents, my lord, but in fact, my lord, this is the second date, my lord. This CD has not come another.
CD call for CD. Huh? Call for CD. Yes. At least after 1 week. Yes.
Date fixed, man.
Your Lordship, previously I am the counsel in this matter. Your Lordship may kindly delete my name from the council.
Permit that he was earlier counsel and his name may be. Yes. Yes. Next.
My petitioner is
You are
in
appearing?
custody since.
You are appearing?
In the 19.
Okay. Okay.
Petitioner is in custody, my lord, since 25/3/2023.
25/3/23.
Yes, my lord.
Okay.
As per statement of the 161 statement, my lord, I am read out that the
What are the offenses?
offense, my lord, 498, 304B, 302/34 of the IPC, 4DP Act, my lord. The
Charge sheet is
deceased
filed.
charge sheet submitted, my lord.
302 or 306?
What happened in this case? My last occasion, she directed me to, my lord, receive the Visra report, my lord. Visra is poisoning, my lord. Found poisoning, my lord. But in fact, my lord, preliminary charge sheet submitted 20th/7/2023, my lord. Keeping investor 170 supply 8, my lord. Today I contact the IO, my lord. Final charge sheet going to submit it as because, my lord, the one of the accused absconded, my lord, and his Mishra report has in the meantime, my lord, received, my lord.
A case of
Another
suicidal,
two
my
minutes.
lord.
So that
As per statement, my lord,
no, no.
now
she,
302, my lord.
It is 302.
For that reason, my lord,
I took the hospital, my lord. Thereafter he succumbed, my lord. As per statement, my lord, she took poison, my lord. I am read out
What
the.
I'll do is, up to date case diary you call for, I'll wait. Up to date case diary. Because let the record be straight.
Yeah.
Wait.
More than a year,
I
dead
know,
hours or oil.
I know you are entitled if you have taken her to the hospital,
Yeah.
then it can't be 302. Yeah.
Next week,
Mishra
and
has
it will-
developed hate
Next week. Next week.
subsequent.
Up to date case diary called for, release the matter after 1 week.
Yes.
After 1 week. Yeah. Yes.
20, my lord, the petitioner is in custody since 31/10/22.
31/10/22. 22.
My lord.
Yes, sir.
Till date, I have instruction that no charge has been framed. Last occasion it was directed. to
Offense.
376.
376.
My lord.
Yes, sir.
My lord,
376.
age of the victim is 26 years.
26 victim.
They went to Kerala, stayed there for 4 months.
Victim is 26 years.
26.
You are 23 years.
23.
Yes.
My lord, one.
Since last 2 years he is in custody. 164 read it.
My lord.
Yes. Read once.
My lord. I am going to that, my lord. Mo. Sandhimana court postai sapan kita. ଶୋଇବା ଘର କବାଟ ବାଡେଇଥିଲା ମୁଁ ଭାବିଲି ବାପା ଆସିଥିବେ ବୋଲି ସେତେବେଳେ କବାଟ ଖୋଲିଲି ଆମ ଗ୍ରାମର ମିଥୁନ ମାଝି ଦି ପିଟିସନର ରବି ମାଝି ଆଣ୍ଡେ ବରିମ ମାଝି ମୋ ଘର ଭିତରକୁ ପଶି ଆସି ମୋ ଆଖି ବାଟି ବନ୍ଦ କରି ମତେ ଘରକୁ ଉଠେଇ ନେଇଥିଲେ ମୋ ଘରୁ ଉଠାଇ ନେଇଥିଲେ ମତେ ସେମାନେ ଉଠେଇ ନେଇ ମୋ ଘର ନିକଟରେ ଥିବା ଏକ ସ୍କୁଲକୁ ନେଇ ଯାଇଥିଲେ ସେଠାରେ ଗୋଟେ ମୋଟର ସାଇକେଲରେ ପାଖ ଜଙ୍ଗଲକୁ ନେଇ ଯାଇଥିଲେ ସେଠାରେ ଜଣକ ପରେ ଜଣେ ମୋ ସହ
At this stage, Mr. Ragada submits that Ragada submits that the recording of evidence has already recording of prosecution evidence has already been commenced, and about 3 witnesses have been examined.
And date last time adjourned to 5/9/2024. Posted.
Be that as it may, तापर लिखो, I'm not inclined to, and yes. Next.
Victim may be examined on the next.
Yes.
That your lordship may
The
observe.
trial court is directed to see trial court is directed to do well to see that the victim is examined, giving preference over all other witnesses.
And if not examined, my lord.
If not examined, yes.
21. May I please, your lordship? Petition of custody since 21/9/2020.
Carefully record, if not examined. Victim shall be examined. Preferentially, if not examined, yes, still date. Yes. Yes.
I know. Petition of custody since 21/9/2023, my lord.
21/9/2023. 23, okay.
My lord, under offense condition 366, 376, 366.
Yes, yes. What are the allegations?
Notice already, sir, my lord.
On notice I am appearing. A married person, as I got instructions, he is a married person having 3 children. The victim is 13 years old at the time of.
I am in custody since my lord 4/9/2023. 1 year 2 days, my lord.
4/9/2023,
my lord.
23. Okay.
And allegation of my lord 498A 304B 34 IPC.
Oh, 34. Yes.
So for the
Yes, sir. You are
case,
husband.
I am the husband, my lord.
Yes.
And this is a case of poisoning, my lord.
Poison
Last,
is-
my lord.
Show me
Yes,
that
yes, my
poison
lord.
is
Last,
taken by her.
yes, my lord. Last occasion, your lordship particularly directed me to place the evidence of the witnesses, the evidence of Kasinath Behra.
Read it.
My lord, I'm relevant person, I am reading, my lord. ମାତ୍ର କିଛି ଦିନ ପରେ ସ୍ୱାମୀ ଶାଶୁ ଶ୍ୱଶୁର ପୁନର୍ବାର ଶାରୀରିକ ମାନସିକ ନିର୍ଯାତନା ଦେଇଥିଲେ ନିର୍ଯାତନା ସହି ନ ପାରି ତା 31/8/2023 ତାରିଖ ରବିବାର ଇପ୍ସିତା ବିଷ ପିଇ ଦେଇଥିଲା ବିଷ ପିଇ ଦେଇ ଅସୁସ୍ଥ ହେବା ପରେ ତାର ସ୍ୱାମୀ ଓ ଶାଶୁର କଟକ ବଡ ଡାକ୍ତରଖାନାକୁ ନେଇଯାଇଥିଲେ।
Yes, Mr.
My lord. But in fact, my lord, one case, my lord, the not 306, my lord. Charge sheet submitted on section 498, 304B, 294, 534, section read it,
It's all right. Thank you. petitioner is accused in so and so case, allegation against the petitioner so and so. The petitioner has placed on record the statement of witnesses recorded under 161 CRPC. Perusal of the statement, all the statements reveals that the wife of the petitioner has consumed poison. Immediately thereafter, the petitioner and his father had taken the deceased to the hospital where she was admitted. However, she died subsequently. The petitioner is in custody since 4/9/2023. Regarding head to the nature of allegation and the evidence form part of the charge sheet and the custody of the petitioner. I'm inclined to admit the petitioner on bail accordingly granted. Yes. Next. 23.
Custody since 2/8/23.
2/8/23. 2/8/23. Okay, sir.
Is the 164 statement of everything I have annexed, page 29.
Yes. 376 and 370. Main. Yes. Foxo. Yes. Petitioner on bail accordingly granted. Yes. Next.
24.
May I present? At in this case, my lord, last occasion, my lord, I called for the instruction regarding the IA for interim bail, my lord.
Sorry, sir.
Last occasion, my lord, I called for the instruction regarding the IA for lord.
Lord, I am for informant.
I am my lord.
The
my lord, instruction has come, my lord.
Interim.
My lord.
Interim, my lord. My lord, I am the wife. Petitioner's mother, namely Basanti Behera, has been suffering illness and she treated under Gaurang Charan Naik, Dr. Gaurang Charan Naik, Karanjia, and advice for a better treatment and refer to SC Medical College. But till date, she has not going to her treatment at SC Medical and require her attendance for the purpose. Further, the ascertained that one Jatin Kumar Dari, who was principal accused in this case, was a parole, but during parole he was absconded from the local land.
Pilot already split out, my lord.
My lord.
Pilot already split out.
Your friend was granted parole.
My lord, I am not taking.
He is absconded.
Now, my lord, I am moving for interim bail, my lord. Just
I know. Interim bail. Thereafter, you will also join.
No, my lord, any stringent condition for week.
In this case, victim has already been examined, informant has already been examined, and the victim has supported the case of prosecution. And in this case, out of 25 charge sheeted witnesses, 23 witnesses has already been. Trial is at flagrant stage.
A deaf and dumb
case, and the co-accused person has been identified in the TI parade.
Deaf and dumb.
You are the only son.
Another brother is in outside.
Petitioner has moved an interim application for release in the international to attend his mother who is stated to be ill. On instruction, it was found that although the mother of the petitioner is not keeping well, but on advice of the doctor to join which medical college?
Not going to her treatment for SC Medical College.
SC Medical College. He has not got her admitted. Petitioner is one of the sons. Petitioner has one more brother. In the instant case, the out of how many witnesses?
Out of
8 witnesses are still pending.
Out of 20.
25
witnesses, 20 witnesses has been examined.
25 witnesses, about 14 witnesses have been. Girl has already been examined, who has supported the prosecution case. The victim girl is a deaf and dumb girl who has been alleged, who was allegedly ravished by the petitioner. In that view of the matter, I am not inclined to enlarge the petitioner on bail. Accordingly, the bail petition is the present petition is dismissed as a corollary.
Bail
as a corollary. the interim bail application is also turned down. I have told, don't file frivolous interim application. Yes, next.
25.
Yes. Yes. Yes, sir.
25, my lord. The petitioner is in custody since 2023, my lord.
28.
2023, my lord.
Okay.
The allegation, my lord, the allegation against me is in my account, they have deposited 7,90,000.
420, yes.
Yes, ma'am.
I am for
7
the,
lakhs?
90,000.
I am for the
How
informant.
much you have paid?
My lord, the thing is,
My
ki
lord.
my money is due from the informant, my lord. My lord, Chinmay. It's a transaction between Chinmay and Sanjay. I have no role between that, my lord. Just because my money is due
How
from
many accused
Chinmay.
are there? Chinmay is also an accused.
Chinmay is also named in the FIR.
He has
It's a
been
transaction
taken
between.
absconding.
No action is taken against the Chinmay, my lord.
My lord, before your lordship pass any order, I may humbly submitted that during pendency of this case, after charge sheet, he has already moved to the court below, giving false undertaking that no case is pending before any other
Have you
court.
done that?
My lord.
No, my lord. I have not filed any application before any court.
So-
Just because I have also appeared here, my lord, on the basis
No,
of.
eight minutes. When this file was made?
This,
On that ground or different?
my lord.
If
Your
that is the
lordship,
case.
26/2/2024, this
No,
application is
when
filed.
was this petition filed, sir?
26/2/2024, my lord.
26/2/2024. This is 24/6/2024. Okay?
Yes, my lord.
Uh,
My lord, the whole difficulty is that the petitioner is in custody and he is unable to communicate with anyone. So that is why all this chaos has happened, my lord.
chaos has to be,
in this case,
dealt
order,
with.
Lordship, can I pray one small thing, my lord? During the pendency of this case, charge sheet has already been filed. If your lordship will allow me, I'll renew my bail application.
Better.
I'm so much obliged, my lord. I'm so much obliged.
Right. Then counsel for the petition submits that his bail plea has been rejected by order dated 7/2/2024. Thereafter, the charge sheet has been filed on
on 17/2/2024.
17/2/2024. Therefore, he seeks to withdraw this petition to renew his bail plea before the trial court on the changing circumstances.
So much
If
obliged.
such application is moved, the same shall be dealt with in accordance with the law. At least you come out of this.
My
No, so much obliged.
That's why I interfered in.
Obliged.
Yes. Can I come up? This file?
ଭାଷଣ ସଭା ହଉଛି ନା
Yes, 27.
27.
obliged.
Item 27. And last time, my lord, I have taken instruction that regarding acquittal, trial ended up with acquittal, my lord.
The interference of this one, man, earlier bail application 826 or 202, your lordship directed expedite trial for so far co-accused concerned. For that,
So see, you should be happy.
ଆମେ ଟିକେ ପଇସା ପତ୍ର ପାଇଥାନ୍ତୁ କିନ୍ତୁ ଖାଲି ଆମର ଲାଭ କଣ ହେଲା ମାଇଲର ଆପଣଙ୍କୁ ନ କହି କାହାକୁ କହିବା ଆଜ୍ଞା ଆମେ ଏଠି ହେଇଥିଲା ଆମେ
Liberty versus lawyer's money, which is important. I think liberty prevails.
ପାର୍ଟି ଗେନ୍ ହେଲା ବେନିଫିଟ ପାଇଲା ଆକ୍ୱିଟାଲ ହେଲା କି ଯାହା ହେଲା କିନ୍ତୁ ଆମେ ଲୁଜର ହେଇବୁ ଆପଣ ଟିକେ ଆମକୁ ଦେଇ ଦେଇଥିଲେ
And there are many ways to get the money.
Withdraw କଥା
Influxes, withdraw. Yes.
28.
28, my lord.
Yes, madam.
My senior is suffering illness, my lord. It may adjourn, my lord.
Okay. Adjourn. On request, adjourn. Yes.
29.
Yes.
76 case there is.
376 case diary. Also case.
Last date.
Yes, next, 30.
My lord, 30 item also CD is required, my lord. Perhaps the CD is attached with another matter, which matter has been disposed of yesterday. So this matter may be kindly urgent.
Call for the CD in this case also. Yes, 31. 31.
That one, my lord, same also. My lord, matter is 302, my lord. CD has not come.
CD, call for CD.
32.
Yes.
Petitioner is in custody since 9/2/2024.
9/2/2024,
my lord.
24, okay.
Charge sheet submitted under section 417, 372N, 294/506 of the
Charge sheet submitted when?
Charge sheet submitted, my lord, 16/4 I. Charge sheet submitted, I got instruction 16/4, my lord. Submitted on 417, 372N,
16/4?
2024.
24.
Yes, ma'am.
Yes.
Under section 417, 376.
Oh, allegation, tell me the
allegation hoji victim hoji 26 years old lady. The 164 statement reveals that they may not came into contact through Facebook. Subsequently, intimacy was developed between them.
164 is there, my lord. ମୁଁ ଅମୁକ ଶୁକ୍ର ସିଂ ସହିତ ଫେସବୁକରେ ଦେଖାଉଥିଲା, ତାପରେ ଫୋନରେ ଯୋଗାଯୋଗ ହେଇଥିଲା, ଫୋନରେ କଥା ହୋଇ ଆମର ପ୍ରେମ ସମ୍ପର୍କ ହେଇଥିଲା। ମୁଁ ମୋର ସବୁ ସୁବିଧା ଅସୁବିଧା ଜଣାଉଥିଲି, ମୋର ବିଟେକ୍ ସାର୍ଟିଫିକେଟ ଭୁଲ ଥିଲା, ଏଇ ଜିନିଷ ମୁଁ ତାକୁ ଜଣାଇଥିଲି। ସେ ମତେ କହିଲେ ମୁଁ +2 ରାଉରକେଲାରେ ଚାକିରି କରିଛି, ମୁଁ ଜାଣିଛି। ସେ ମତେ କହିଲେ ମୁଁ ସରକାରୀ ଚାକିରି କରୁଛି, ଜେଇ ଅଛି। ମୋର କହିଲେ ମୁଁ ୟୁନିଭର୍ସିଟି ଦେଖିଛି ଏବଂ ସେ ସାର୍ଟିଫିକେଟ ଠିକ କରାଇଦେବି। ମତେ ତାଙ୍କ ସହିତ ଯିବାକୁ କହିଲେ, ମୁଁ ରାଜି ହୋଇଗଲି। ତାଙ୍କ କଥାରେ ଯେହେତୁ ଆମର ପ୍ରେମ ସମ୍ପର୍କ ଥିଲା, ସେ ଡେଟ୍ ମଧ୍ୟ ଠିକ କରିଥିଲା। ଆମେ ଜୁନ ପ୍ରଥମ ସପ୍ତାହରେ ଯାଇ ସେ ଏବଂ ମୁଁ ଯାଇଥିଲୁ, ସେ ରୁମ୍ ବୁକ୍ କରିଲେ, ଆମେ ଆମର ଆଇଡି ପ୍ରୁଫ ମଧ୍ୟ ଦେଇଥିଲୁ।
And he is 24 years.
Yes, ma'am.
The girl?
Girl 24.
Petitioner
34
years, my lord.
Girl is also 24.
Petitioner 31. Sorry, petitioner 24 and girl is also 24.
Are you sure? What have you written?
Yes, my lord. Yes.
Huh?
Yes, my lord.
But forcibly,
medical
medical report silent, my lord.
Medical report in late, my lord. Incident was happened, my lord.
Medical report I have filed
10/12/24, my lord.
10/12/24? Okay.
But the incident was happened
10/12/23. 10/2/24.
June, my lord.
9/10/2/23. 10/2/24 ରେ ଏକ୍ସାମିନେସନ ହେଲା। ଅକରାନ୍ସ ହଉଛି ଏଫଆଇଆର ଦେଲେ 9/2/2024 ଆଉ ଅକରାନ୍ସ କହୁଛନ୍ତି ଯୋଉ ହୋଟେଲ କୁ ଗଲେ ମୋ ସାଙ୍ଗରେ ସେଟା ହଉଛି 6/7/1/2024 ବିକଜ ଦି ହୋଟେଲ
January.
January 24
And medical
report I have filed before Lordship's board.
Date tell me. Date
my lord 10/2/2024.
10/2.
And the person of that hotel, they have been examined by the investigating officer. He stated that Ambho hotel register ତନକରେ ଜଣା ପଡିଲା କି ସୁକୁରା ସିଂ petitioner the victim ଗତ ତା 6/7/6/7/1/24 ରାତିରେ ଆମ ହୋଟେଲକୁ ଆସି ନିଜ ପରିଚୟ ପତ୍ର ରୂପେ ଉଭୟ ନିଜର ଆଧାର କାର୍ଡ ଦେଇ ରୁମ ନମ୍ବର 306 ରେ ରାତିରେ ରହିଲେ। ଏଟା 7/1/2024
FIR
9/2/2024।
Petitioner is accused during the investigation, the statement of the victim under 164 CRPC was recorded. She, in her statement entry, has stated that she has been in relationship with the petitioner. The petitioner, on the pretext of correcting the error in the certificate, which certificate?
BTech
certificate. Took her to Raulkela. Both of them checked into an hotel and stayed together. On that day, the petitioner forcefully contacted. On that day, petitioner has sexually assaulted the victim. victim. Subsequently, victim, the incident had taken place on
6 ତାରିଖ ରାତିରେ Selected-
January.
ଆଜ୍ଞା
6
6/1/2024
However, the FIR is registered on
9/2/2024.
the medical evidence collected by the police also shows that there is no symptom of recent sexual intercourse. Regarding to the fact that the petitioner is a 24-year-old boy and the victim is 24. Victim is also 24. They were in relationship. Admittedly, they were in relationship. The petitioner is in custody since 9/2/2024. I'm inclined to admit the petitioner on bail accordingly. Granted. Yes. 33.
I'm on VC, my lord. I'm on VC, my lord.
Yes, sir.
Yeah.
Yes, sir.
The present petitioner is in jail custody since 15/3/24. It is alleged that
15/3/24.
yes, my lord. And
Yes.
the police have seized some contraband ganja from a standard vehicle abandoned near the Damanjodi police station.
Ganja, what is the quantity?
My lord,
Quantity is 197.900
197.
kgs. It is recovered from a abandoned vehicle, a Desire car.
These required.
So,
I'll have to call for CD
So,
because the
that-
quantity
yes,
is.
that car was actually registered in the name of Trilochan Maji, my lord. And the
I'll
Trilochan Maji is made, as per the statement of the owner of the car, I'm in.
Yes, I know. I understand it, but I'll have to call for CD. Unless CD is there, can't be done. Call for the CD, release the matter after 2 years. Okay.
Yes. Much obliged.
Yes.
35. He was there. Jet similarly.
Notice we
In
notice required to serve.
requisite filed lately.
Was there.
Since requisite filed lately, the notice could not be served on opposite party number 2. The requisite which has been filed, within file may be utilized for the purpose of serving opposite party number 2. Release the matter. Yes. Next.
Because my lord, the trial is
So this is bail matter. Trial, then that's good. Trial should have. Some evidence should come so that they may not support and I'll utilize. No problem. Yes.
36.
সেটা কোটা সেটা কেটে একটু
Yes.
36.
36. Is there? Is there there? Mr. Rahul,
My lord?
Is there there?
Yes, my lord.
Yes. What is the offense?
My lord, 363, 66, 376, 21, 306.
And POCSO.
With the 4 bit 1 and 6 of
Yes.
POCSO.
Non-APS for the petitioner. Mr. Rahul counts for the state submit that he has received the CD. Least the matter is dead to. Yes.
37.
May I plead your lordship? Your lordship, I am on VC, your lordship.
Yes.
My lord, I may be. I'm praying.
Oh, 37.
My lord,
Okay.
CD is required, my lord.
No, 37. This is
37, my lord.
37.
Yes.
Yes. So tell me.
Your lordship, I am in custody since
37. Yes.
Your lordship, I am in custody since 29/9/2023, your lordship.
29/9/23.
Your lordship.
29 September 23.
Your lordship, your lordship.
Okay.
Your lordship, charge sheet filed on 27/11/23, your lordship.
27/11. Okay.
Your lordship.
Yes.
Your lordship, right now 11 numbers of witnesses are examined, your lordship. 9 numbers of witnesses are failed to identify. Your lordship, IO did not.
When this last witness has been examined? Last witness?
Your lordship, last witness examined on 6/3/2024, your lordship.
Yes. Yes.
Your Lordship, the police did not did not conduct the identification parade, Your Lordship. Till date, Your Lordship. 11 numbers of witnesses are examined.
1 minute.
Petitioner may be served the copy of the positions.
No, they see there are many witnesses have already been examined. Let him renew his bail plea after the fresh materials.
Yes.
You see, since the many witnesses have already been examined, according to you, they have
Your
not
Lordship.
supported the prosecution case, then
Your
it
Lordship.
would be ideal for you to renew your bail plea with the trial court, because in the available material, the trial court will call decide the matter. Because see,
Your
your
Lordship.
bail application was rejected earlier.
Your Lordship,
So
defense
I'm-
evidence
I'm-
also
I'm-
closed, Your Lordship. Defense evidence
I-
also closed and the stage is for argument,
I
Your
can
Lordship.
go into, but how many matter I can go into? If the trial courts are, what will the trial court do?
Your Lordship.
If High Court will do everything,
Your Lordship.
to give an opportunity to the trial court also,
Your Lordship.
isn't it? Yes, right on. Petitioner is agreed by the order dated 22/2024, by which the bail plea of the petitioner has been rejected. Then counsel for the petitioner submits that subsequent thereto, vital witnesses have been examined by the prosecution, hence, he seeks withdrawal of the present petition to renew his bail plea on the changing circumstances. The liberty is granted to the petitioner to renew his bail plea before the trial court. The trial court shall decide the bail application within 15 days on the basis of the available material on record.
Yes,
Within 15 days, the trial court has to decide your application.
Obliged, Your
Thank
Lordship.
you. Thank you. Yes.
Please note.
38.
May I please, Your Lordship?
Yes, madam.
Alleged offences are 376-2 417 and 506. In last two occasions, Your Lordship are directed to adopt in CD, Your Lordship.
Is there?
And
CD?
both are major.
1 minute. It is there?
No, my Lord, it is not there because
In last 2 to 3
yes,
occasions.
yes, I do admit him and my Lord.
Do you have 164 with you?
No, Your Lordship, only 161. Certified copy of 161, statement of victim.
Do you have any idea whether 164 statement is recorded or not?
Yes, recorded.
What to do, sir?
My
Two
Lord,
occasions.
Lordship, may I pay for?
My Lord, Your Lordship may
By way of
give me any third time.
last and final opportunity.
Yes, my Lord.
1 week time is granted.
Next Friday, ma'am. Next Friday.
1 week time is granted for obtaining the case diary. Lease the matter on Friday.
Okay. Deeply obliged.
You are in custody since
Custody since, Your Lordship, 20th February.
February?
The 6th February, 2024.
Oh, 1 year you should stay 1 year. What?
Both are major, Your Lordship. What has happened?
They were
Consent?
in relationship.
Yes, that is that.
Okay, we'll see. Let the case study come. Yes. 39. Yes.
My Lord, I may be pardoned, my Lord. My Lord, this is a matter of 395-120B for 11, my Lord. The order, the accused petitioner, as per the order of rejection by the land, the court below, that accused petitioner identified in the PI parade. But in the meantime, my Lord, Your Lordship may kindly allow me to obtain the city, my Lord.
You are identified.
But in the my lord, my lord, alleged truck has already been recovered, my lord.
All right, but
My lord,
yes.
40 short date may be given.
He will give the short date. Yes.
Item 40, I may be permitted, my lords, from
Yes,
BC.
sir. Yes, sir.
My lords, petitioner is in custody since 19/3/2024, my lords. He
Yes.
surrendered before the court below on that date and he is in custody. Charge sheet submitted on 14/8/2023 under section 376(2) IPC and 6 POCSO, my lords.
Yes.
On the date of FIR, my lords, the petitioner is a young boy, 18 years, 4 months, my lords, and the victim girl is 17 years, my lords.
Yes, sir.
And as per the prosecution case,
Read 1 minute.
Available, my Lord.
164, 1 minute.
ମୁଁ ଅମୁକ 1 ବର୍ଷ ହେଲା ଗୋଟେ ପୁଅ ପବିତ୍ର ଦାସକୁ ଭଲ ପାଉଥିଲେ ଏବଂ ଗତ 12/2/23 ତାରିଖ ଦିନ ଉକ୍ତ ପବିତ୍ର ଦାସ ଆମ ଘରକୁ ଆସିଥିଲେ। ମୋର ଘରେ କେହି ନଥିଲେ। ଉକ୍ତ ପବିତ୍ର ଦାସ ମୋ ସହିତ ଶାରୀରିକ ସମ୍ପର୍କ ରଖିଲେ ଓ
And the custody from 19/3 to 2024, I am inclined to enlarge the petitioner on bail with following conditions. The condition, additional condition, he will not be in contact with anyone. Yes.
deeply obliged.
Yes.
My Lord, disposed.
Discourse, yes. Yes, sir.
Next, please. 302, 201, 120B and 34.
CD is there?
Yes, ma'am.
Yes.
The
Yes,
allegation
sir.
in custody since 18/11/23.
18/11/23.
23.
Okay.
And the offenses are 302, 201, 120B, Redu 34 IPC. The allegation is that FIR was lodged stating that his son had went to his workplace, did not return in the night. So FIR was lodged. Subsequently, he was searched and his body was found.
What was this petitioner's role?
They said that the petitioner
Was
took
seen
took
last
him
week.
took him up on liquor, taking liquor, and thereafter assaulted him. And the further allegation is that in the charge sheet, no evidence is there. In the charge sheet, further the statement of the police is that he was having illicit relationship with the wife of the deceased. So there was a collision, and that is how he was killed.
Yes, that is
What
the
is
matter of fact.
linking evidence?
That is the only the charge sheet. It is the my submission would be that it is the figment of imagination of the IO. Let
Let's
that be.
see what are
My
the
lord,
evidence.
I may be allowed to read one of a statement, my lord. Last signature, my lord. My lord, ମୋ ନାଁ ସଂଗ୍ରାମ ଶେଖର ସାହୁ ମୁଁ ବର୍ତ୍ତମାନ ବରଦର ବର୍ଜର ପେଣ୍ଟ ସେଲ୍ସ ଅଫିସର ଭାବେ କାମ କରୁଛି ଓ ସାଇପ୍ରିୟା ନଗରରେ ଗୋଟେ ଭଡା ଘରେ ରହୁଛି। ଆଜି ତା 17/11/23 ତାରିଖ ଦିନ ଚାନ୍ଦିଲି ଥାନା ଆଇଆଇସିଙ୍କ ସମ୍ମୁଖରେ ଏହି ବୟାନ ଦେଉଛି ଯେ ଖଲିଗୁଡା ଗ୍ରାମର କାର୍ତ୍ତିକକୁ 6 ମାସ ହେବ ଜାଣିଛି। କାର୍ତ୍ତିକ means my lord, ମତେ ଜି କାର୍ତ୍ତିକ ପ୍ରାୟ 3 ମାସ ପୂର୍ବେ କହିଥିଲା ଯେ ମତେ କୌଣସି ଦୋକାନରେ ରଖିବାକୁ। ମୁଁ ତାପରେ ତାକୁ ଗୋଟେ ବର୍ଜର ରଙ୍ଗ ଦୋକାନରେ ରଖିଦେଇଥିଲି। ଗତ 15/11/23 ରାତି ପ୍ରାୟ 10:30 ସମୟରେ କାର୍ତ୍ତିକ ମତେ ଫୋନ କରି କହିଲା ତୁ ସାଇପ୍ରିୟା ନଗରରେ ଥିବା ପଡିଆ ପାଖକୁ ଆସିବାକୁ କହିଲା। where the dead body of a deceased was found there.
Yes.
ମୁଁ ତା ପାଖକୁ ରାତି 12ଟାରେ ଗଲି। ମୁଁ ଗଲା ବେଳକୁ କାର୍ତ୍ତିକ ଆଉ ଯିଏ ମର୍ଡର ହୋଇଛି ଦୁଇ ଜଣ ସାଇପ୍ରିୟା ନଗରର ଫିଲ୍ଡରେ ବସି ମଦ ପିଉଥିଲେ। ମତେ ସେମାନେ ଗୋଟେ ବିୟର ଦେଲେ, ମୁଁ ସେଟାରେ ଅଧା ପିଇଲି। କାର୍ତ୍ତିକ ହାତରେ କିଛି ଗୋଟେ କାଗଜ ଗୁଡାଇ ଧରିଥିଲା। ମୁଁ ତାକୁ ପଚାରିଲି କଣ ଧରିଛୁ ବୋଲି, ସେ ମତେ କହିଲା ଯେ ସେଟା କ୍ୟାଲେଣ୍ଡର ଧରିଛି। ତାପରେ ମୁଁ କହିଲି ଡେରି ହେଲାଣି, ମୁଁ ଘରକୁ ଯାଉଛି କହି ପଳେଇ ଆସିଲି। ତାପରେ ଦିନ ସକାଳୁ ଶୁଣିଲି ଯେ ସାଇପ୍ରିୟା ନଗରରେ କାଲି ରାତିରେ କାର୍ତ୍ତିକ ସାଙ୍ଗରେ ବସି ମଦ ପିଉଥିଲା ଲୋକର ମର୍ଡର ହୋଇଛି ବୋଲି।
What is the stage?
My lord.
Trial stage.
Trial stage, my lord.
That is the only.
My lord, by connecting this, the 27 confessional statement leading to discovery the weapon, my lord, that a motorcycle observer pipe, my lord, has been seized, and
I am giving you two options.
My lord.
You are in custody since 18/11/23. Wait till 1 year is crossed, or I'll relegate you to trial court to renew your bail. Whichever is suits you.
But your lordship will kindly say whether this
I have
evidence.
straight away told you whichever suits you, take it.
No, my submission would be this only evidence doesn't lead that there is a prima
1 year.
facie.
Had it been about custody of 1 year, I would have considered. You are not even 1 year. So I'll simply adjourn it. Or shall I tell that these witnesses shall be examined first?
Your lordship may call it after 1 month.
Yes, after 18th of November. 1 year, after 1 year, I'll consider.
After 1 month, correct.
No, meanwhile, no, not 1 month. Write down in the petitioner is in custody since 18/11/2023. There are the present case is based on circumstantial evidence. However, the prosecution is relying upon the evidence of which witness is that? Who is that witness name?
Sangram
Sekhar Sahu.
One evidence of one Sangram Kishore.
Sekhar Sahu.
Yes, Sekhar Sahu, who has stated in his statement at 160 that he had lastly seen the present petitioner with the deceased at
Your
12
lordship,
o'clock preceding day.
your lordship may call it after 2 weeks. He has already been examined. I will produce the evidence and thereafter it will be.
And I am recording that. He has already been examined.
Already been
Yes,
examined.
Already been examined.
No, my lord.
No,
that is
my
from
friend
my-
says, my friend says he has already
Are you
been.
sure? Man. So least after 2 weeks.
My lord.
Least
My
after
lord.
2 weeks. Our examine if he's supporting prosecution.
Yes,
then
yes,
the
my
story
lord.
is different.
Yes, that will be
If he's
different.
not supporting, I'll let
Yes,
the
my lord.
yes. Or at least after 2 weeks. Huh? Learned counsel for the petition submits that the
Sangram Shekhar Sahu.
the vital witness Chandrasekhar
Sangram Shekhar Sahu.
Shekhar Sahu.
who has been cited as a witness to the last scene of the petitioner with the
Sangram Shekhar Sahu.
has already been examined.
My
And
lord.
he wants to place on record the
My lord.
evidence of the said witness
My lord.
to substantiate his bail plea. Leaves the matter of 2 weeks. 42. He'll give a date. Don't worry. Get the copies. Let us see.
My lord, my lord.
Yes. Yes. Yes.
May I?
Yes, sir.
Offense under section 376(2) and 470
Custody.
IPC, custody minor is 2424, my lord.
2424.
Charge sheet submitted, and the FIR lodged after 1 month. It is a case of elopement, my lord. They both fled away from the village, living in different place. After 1 month, return. After return, the mother of the petitioner left the victim in her house. Thereafter, FIR was lodged. This is the
You are 26 years.
my lord. The 164 statement.
CD is there?
Yes, my lord.
She refused to medical examination. And
That
both
did
of
not
us.
matter, my lord. My lord, in her 161 statement, my lord, that this accused petitioner has carried out to her and lived as the wife and husband in a outside. And after 1 month, this petitioner come back and left to this.
Left this
victim.
girl.
Yes.
Left this girl.
And that has been mentioned in
164.
164 also.
164. Chetra,
What is the age of this girl?
17 years, 3 months.
17 years.
Is 26 years.
ଆମ ଗାଁରେ ଆସି ପହଞ୍ଚିଲୁ ତାଙ୍କ
He has been examined. You are
ତାଙ୍କ
26
ଘରେ
years.
ଛାଡ଼ିଦେଲେ ତାଙ୍କ ମା ଆସି ମତେ ଆମ ଘରେ ଛାଡ଼ିଦେଲେ. Thereafter FIR was lodged.
Just verify.
Oh,
Just let him verify whether this victim has been examined or not.
Examined or not.
Wait, verify. Mr. Rahul and counsel for the state to verify as to whether the prosecutrix in the present case has already been examined or not. If prosecutrix has already been examined, the copy of her evidence shall be produced on the next date appearance, least up to 2 weeks. Yes. 43.
No criminal antecedent in any nature even 52 kg 500 milligram and my lord final PR submitted on 12/8.
Custody
14/4 my lord 2024.
my lord.
My lord may directed to verification of criminal antecedent.
Verify criminal antecedent.
ନା ମୁଁ ତଳ କୋର୍ଟ ଦେଇକି ମୋର କିଛି କେସ୍ ନାହିଁ ଯଦି ଥିବ ମୁଁ ଯିବିନି ବେଲେ ହଜୁ ସେଇ ଡାଇରେକ୍ସନ
52 kg.
And
ଗୋଟିଏ କେସ୍ ଥିଲେ ବି ମୁଁ ଯିବିନି
6 ମାସ
506 ବି କେସ୍ ନାହିଁ
6 ମାସ କେବେ ହେବ?
ଫାଇନାଲ ପିଆର ହେଲାଣି ଆଜ୍ଞା 12/8
We are in
ଆଉ ଅଛି 12/8/2024 ରୁ ଫାଇନାଲ ପିଆର ହେଲାଣି କିଛି କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ନାହିଁ ଏନି ନେଚର ମିଲର ଡାଇରେକ୍ସନ ଦେଲେ ବି ହବନି.
My lord, in Indiga, in this case, Indiga, my lord, he has been conscious and exclusive.
he was carrying.
So, regarding the.
What is the stage of the trial, whatever?
ଟ୍ରାଏଲ ଆରମ୍ଭ ହେଇନି ଏବେ ଫାଇନାଲ ପିଆର ହେଲା 12/8/2024.
Final peer also, madam.
Huh?
Final peer, I may be opting the final.
Final.
ମୋର ରହୁ ହଜୁର ମୁଁ ଦେଇଦେବି ଫାଇନାଲ ପିଆର ମୋ ପାଖରେ ସାର୍ଟିଫାଇଡ କପି ଅଛି.
I will grant bail, but record should be straight. Huh? How much time? What, 2 weeks?
Final.
Final.
ଏଇଥିରେ ଥିବ ଫାଇନାଲ
Submit that. Short for the final appear. Huh? Release the matter after just 2 weeks. Huh? So I'll grant bail.
My lord, everything is with him.
Huh?
Except everything is with him. Final PR.
No. At least he will have that satisfaction that something is there. 44.
May I please your lordship?
44, my lord, I may be pardon that. CD is required, my lord, 302, my lord, and
More
my
than
lord and senior.
more than
police-
30, more than 30 months in custody, my lord.
All right, but it is a 302.
My lord, my lord.
Let the case
Some of
there.
deposition.
No, my lord, we
Next.
tried to
To
witness have already examined and submitted the copy of the deposition.
Yes. Don't, you file it. You file it. File it.
Right.
Yes. Next.
Copy supply to the, on the two copy they will check.
Yes. Upon the next.
45.
45.
Offense is under section 20B2C. Total quantity of contraband article is 45 kilo.
Yes.
And
Antecedent. Antecedent. Have you got?
No, my lord, no, my lord,
antecedent.
no incident.
Custody since?
Custody since, my lord, 19/3/2024.
My lord, there is 3 criminal antecedent in other offense, my lord. Criminal antecedent, my lord.
Other offenses.
My lord.
Because last day, it was directed that the states to obtain instruction with regard to the criminal antecedent of the present petition as well as obtain case diary.
Yes, my lord.
Case diary,
And
PR,
place the same before this court and next.
Case diary has not come, my lord, but.
Get the case diary.
the
Because last order-
my lord, it is a PR by the excise
PR.
department. So there may not
But
be.
this is the order of coordinate bench. I can't defy that order.
Yes, it will not be there.
Mr. Rahul and council.
By 1 minute.
State submit that pursuant to order dated 2/5/2024, he could not get the case diary. He seeks 1 week adjournment, lease the matter up. Yes.
46.
But my lord, in this type of case, there won't be any case diary. Because it is by the excise department itself.
PR report.
PR is there. PR is there.
PR
Police
report.
file the PR.
But last order, the coordinate bench has
6
written
hours.
case diary, so therefore I am repeating it. But PR.
PR.
No, but they are also maintaining the.
They are
PR,
also.
PR only.
In that format they file it.
Their formats.
173 format they use it.
We are calling
That I have already filed by the annexure 1 value.
We are
Already
calling the
filed.
same.
You can call it PR or
CDO.
report under 173, whatever. Yes. PR oblique CD.
My lord, on behalf of Ms. Patra, I am submitting.
Yes.
The petitioner is in jail custody since 22 March 23 under section
20,
22, 23, 23.
22, 3, 20,
23. 23. Section
23. Okay.
or 2376 2N 506 313 of IPC.
You have all
Case diary, my lord.
case diary,
164
medical
statement.
examination report,
Medical exams report is there, my lord.
164, everything. Read 164.
And it is 2 pages, but I am reading the relevant portion.
What is the age of the victim?
And the victim age
40.
is 37 years.
37. He is
Petitioner age is 40 years.
40.
And victim has 2 children, my lord. Having 2 children.
Both are married.
And in the medical examination report, though it was conducted just day after to
1 day.
FIR,
1 day.
1 day after the FIR, my lord. But the occurrence was took place 5 months before. Occurrence.
What was the allegation?
And 313 miscarriage is there, madam, in the medical examination report. 313 is there.
He already there.
313 is made out.
And for the informant.
4 statements, he has also stated that the husband was not there, so she has kept relationship. This present petitioner has kept relationship with him, and then given some tablets.
He has committed a divorce in the year 2010. Both are
You are
classmates.
appearing for whom?
For the informant.
What do you say?
That he willfully is the accused had a harassed.
You are married, having
Yes.
children, you kept relationship with him.
No,
I am also married.
kept relationship,
Hmm.
but without the knowledge that he has assured me that in a pretext that I will marry.
What
and-
marry you? You are already married.
No, my marriage is reserved since 2010. After that, he is my batchmate and assured me that for a
all
marriage.
consensual. All consensual.
My lord, having the evidence that already he has made a notary marriage, though it is not valid, but accordingly, he has produced me as a spouse in his postal deposition, postal deposit, as the insurance note that it is I am spouse. And in the meantime, he has married.
He is mentally married, otherwise not. But it is a consensual thing.
My lord,
It is a consensual.
consensual in a pretext to marry.
Oh.
But that means here is a pure promise of marriage.
Read out.
Alleged offense under section 24.
Yes.
Lordship, the petitioner is in custody since 30/3/2024, Lordship.
30/3/24.
2024, Lordship.
Okay.
Lordship, FIR lodged in the year 21/5/2023.
What is the recovery?
Lordship,
500
nothing was seized from the conscious possession of this petitioner. The FIR story is that
The patrolling party received a credible information that storage of
What is recovered?
It was seized from his home, 502 kg, 502 kg. It was seized from the home. When the raiding party has gone, he was played away. Then matter away. The charge sheet was not submitted, but it was awaiting the demarcation and a spot map. It was awaiting. And another thing is that, my lord, he has similar number of antecedent.
One antecedent.
Two antecedent is
But
there
we
of similar nature.
37 directly.
But in all the cases, nothing was seized from the.
But whatever. 37. Withdraw to repeat it at the appropriate place.
Lordship, in one of the cases, he is already on bail, and
Maybe, but recovery is so huge, I can't.
and meanwhile, charge sheet has also been.
And consequently, the petitioner seeks to withdraw this petition to renew his bail plea only for trial court at appropriate stage. With this liberty, the petitioner is disposed of. Yes.
On behalf of Mr. Parila, kindly taken out two chapter.
On request at them. Yes.
Here, my lord, the present petition inside causes in 2/3/2024, my lord. 2024, my lord.
Yes.
Initially, FR was restored under section 498/302/201 of IPC. In the
Charge sheet filed.
charge sheet submitted under section 498/306 of IPC, my lord.
306.
My lord. And here, my lord.
Your husband.
My lord, present husband of the deceased, my lord. The immediate neighbor, my lord, he is stated in the 161 that on the date of occurrence, both the husband and wife, they are working, and on the same day they came to the house, and the husband left the house. Thereafter, the deceased took the small child with her to the upstairs. Thereafter, she committed a suicide, my lord. I am placing the statement of Minati Bhutia.
FR was lodged on under section 302. Subsequently, charge sheet was submitted under section 306. Before charge sheet submission, he has filed that rejection order was there. So let him renew his prayer because 306 is there.
That's right. Now 302 stage you have gone. Now it is 306. The trial court has to consider it. Right? Petitioner is agreed by the order dated 8/4/2024, whereby his bail plea has been rejected. At that point in time, the investigation was still going on. The FIR was registered for offenses alleged offenses punishable under section 498A, 302 and 301 IPC. Subsequent thereto, the charge sheet has been filed on
my lord. The charge sheet submitted on 29/4/24.
29/4/2024 for alleged offense under section 306,
498A,
306 and 201.
Only that 498A, 306.
Only for the 498A and 306 IPD. On these changing circumstances, the petitioner should approach the court of first instance by renewing his bail plea. Therefore, I am not inclined to entertain this bail application at this stage. However, liberty is granted to the petitioner to renew his bail plea before the trial court on the changing circumstances. The trial court is directed to decide the application within 15 days from the date of moving out. Yes.
51.
May I please?
Initially, FIR registered my lord 363 IPC. Subsequently, the petition was forwarded under section 3762A, the 6 POCSO my lord. Custody my lord since 4/1/2023.
201 allegation. Main accused is another person. He has throwing the dead body along with the main accused. That is the.
302 after 1 week. After 1 week, call for the CD. He is implicated as 201 only.
My lord, let the CD come, my lord. I will get checked.
201, then he is entitled. Yes.
Thought that maybe.
He'll give you. Don't worry.
And in the meantime, my lord, some of the witnesses were examined, my lord. Let me give that.
Let us see. If the allegation is only 201,
then he is saying that. Let me give that question.
Co-accused statement or more questions.
And if the evidences of any witnesses are examined, just see, get the photocopy. I don't need certified copy and all. And get the certificate so that I can dispose it of immediately. Yes. Yes. 50.
Item 54, I may be permitted. Item 54, I may be permitted, my lords.
Yes, yes.
My lords, petitioner is in custody since 19/12/2023, my lords.
Yes.
And charge sheet submitted on 8/2/2024. Offense under section 3762N, 323, 328, 384, 506 IPC, my lords. As per prosecution records, my lords, it is a consensual relationship between a married man and a major lady, 22 years of age, my lords.
You are 40 years.
I am 40 my lord.
Late 22
My
years.
He
lord.
is already married.
My lord.
He is already married guy. What is the allegation? Just see, 164. read.
My lord, 164 was recorded, but the copy is not available with me, but 161 is there.
164, get the 164. The state council seeks one adjournment. CD hasn't come?
CD available.
Adjournment to obtain the statement of the victim recorded in 164 CRPC. This is the matter of one. Yes.
My lords, ordered may be canceled twice adjourned, my lords. Let's see, may fix it.
Yes, yes. Let us see 164.
ଯଦି 164 ଅଛି ଦେଇ ଦିଅ ନା କି
ଆପଣ ପାଖରେ ଅଛି 164?
I don't have.
Wait.
55 million. I'm a young boy, 22 years, and the victim.
Young boy, 42 years.
20, ne? 22 years.
22 years, yes.
And the victim will 19.
19.
And will though in her.
Here CD required 376 to 2A CD requirement.
For CD 1 week up. Just 1 week. Leave
1 week.
Because he is in custody since
9/3/2024.
9/3/2024. 24. See, he is 22 years. And the girl is.
give 164 and medical exam.
164 mo pa nahi, 161 ଅଛି ଆଉ
164 if you have, give it.
160.
Otherwise, call for the CD.
1 week after, because
1 week after, yes. Yes.
56.
If you, whatever you have, you please get a copy and give it.
Yes, charge sheet 161.
Give that copy also. If they can't get the CD next time, we will rely upon this and decide it. Yes.
56.
Yes.
1 week after.
1 week after. Okay.
May I please? Both are parents in law.
57? Yes.
Both are parents in law.
Huh.
Due to heart attack, my lord, the daughter-in-law succumbed, my lord. As per statement of one Sosmita Bholo, I read out the statement, my lord.
Yes.
ଦିଅର ଦେବରାଜ ଭୋଳଙ୍କ ପରିବାରରେ ଆମେ ଆମ ପରିବାର ଗୋଟେ ଛାତ ତଳେ ରହୁଛୁ, ହେଲେ ଭିନ୍ନ ଆମର ତାଙ୍କର ଚୁଲି ଅଲଗା। ଗତ ବର୍ଷ ଅଶ୍ୱିନୀ ମାସରେ ରାଜା ଭୋଳ ହଜବେଣ୍ଡ ମନରାଜିରେ ଚାଷଙ୍ଗରା ସବିତା ଜେନାଙ୍କ ଝିଅ ପୂଜା ଜେନାକୁ ବାହା ହୋଇ ଘରକୁ ଆଣିଥିଲା। ତାଙ୍କ ଘରେ ଚଳଣି ଭିତରେ ବେଳେ ରାଜା ମଦ ପିଇବା ଯୋଗୁ ସେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଝଗଡା ହୁଅନ୍ତି। ଗତ 18/11/2023 ତାରିଖରେ ରାଜା ମଦ ପିଇ ଆସି ପୂଜାକୁ ମାଡ଼ ମାରିବାରୁ ସେ ତା ମାକୁ ଫୋନ କରି ଡାକିଲା। କିଛି ସମୟ ପରେ ପୂଜାର ମା ଆଈ ମାମୁଁ ଆସି ଆମ ଘରେ ପହଞ୍ଚିଲେ। ସେମାନେ ରାଜା, ତାର ବାପା ଦେବରାଜ ପିଟିସନର ଓ ତାର ମା ରଞ୍ଜନା ସହିତ ଝଗଡା କରି ସେମାନଙ୍କୁ ବାଡେଇଲେ। ଉଭୟ ପକ୍ଷ ଏମିତି ଝଗଡା ଲାଗିବା ଦେଖି ପୂଜା ଦ ଡିସିଜ କାନ୍ଦି କାନ୍ଦି ଦୌଡି ଆସି ତାର ବଖରାରେ ପଶି ଭିତର କବାଟ ଦେଇ ନିଜ ହାତ କାଟି ପକାଇଲା। ଏହା ଦେଖି ସେଠାରେ ଥିବା ସମସ୍ତ ଲୋକ ମାନେ ତାକୁ ଅଟକାଇଲେ। ବାଣପୁର ମେଡିକାଲ ନେଲେ। ରାତି 3ଟାରୁ 4ଟା ବେଳେ ମେଡିକାଲରୁ ଫେରିଲା। ତା ପରଦିନ ସକାଳେ ତାଙ୍କ ଘରେ କେହି ନଥିବା ବେଳେ
father-in-law, mother-in-law. Husband was absent at that time. And the allegation is administration of poison.
No, ହାତ କାଟିଲା।
ହାତ କାଟିଦେଲା। ତାପରେ
allegation is administration of poison.
ତାପରେ ରାଜା ଭୋଳ ବାଲୁଗା ଯାଇଥିଲା। ତାର ଶାଶୁ ଗାଁ ପୋଖରୀକୁ ଗାଧେଇବାକୁ ଯାଇଥିଲା। ତାର ଶ୍ୱଶୁର ବାଳେଇ ଗାଁକୁ ଯାଇଥିଲା। ସକାଳ ସମୟ 7ଟା ହୋଇଯିବ। ମୁଁ ମନ୍ଦିରରୁ ଆସି ଘରେ ପହଞ୍ଚିଲା ବେଳକୁ ପୂଜା ମତେ କହିଲା, ମାମା ଶାଶୁ କୁଆଡେ ଗଲେ, ତାଙ୍କୁ ଡାକି ଦିଅ, ମୁଁ ବିଷ ଖାଇ ଦେଇଛି, ମତେ ମେଡିକାଲ ନେଇଯାଅ। ଏହା ଶୁଣି କଣ ତୁ କଲୁ କହି
164
ସାହି ପଡିଶା ପାଟିକୁ ଡାକିଲି।
that witness.
ପୂଜା ଶାଶୁ ଖବର ଦେଇ
This is 161 he is.
ତାପରେ ମେଡିକାଲ ନେଲେ ଆଜ୍ଞା। That is the
164 କଣ?
164 same thing, madam. ସେ କହିଲା ଯେ ମୁଁ ବିଷ ଖାଇ ଦେଇଛି।
First that girl has cut her hand. Okay, in the night when the
assaulted by the in-laws.
quarrel took place between the in-laws of
only
her in-law and the deceased mother and father.
There is no
subsequently in the morning she says I have taken
only dispute. There is the in-laws and deceased. No allegation against the husband, madam. But suicidal note is there, madam.
What she writes?
Suicidal note, madam. Suicidal note, she has not stated anything about
The father and mother.
father and mother. No
What-
one is
what-
responsible for.
One minute, 1 minute. What?
I'm reading my lord that. ଯାହା ବି ହେଇଛି ସେଥିପାଇଁ କେବଳ ମୁଁ ଦାୟୀ ମୋ ଯୋଗୁ ସବୁ ତାମସା ହେଲା ମୋ
Is there?
my case diary is not available. Lordship may
No,
dispose
direction
of-
was there, therefore I'm saying.
No, my direction was there, but it is not available.
20th of June 2024, the coordinate bench has directed you to get the case diary. Without case diary, I can't hear it now.
Two times
On
order was passed.
20th 6 2024, the coordinate bench of this court has directed the state to obtain case diary. However, the case diary is not available with the prosecutor, hence he seeks 1 week time. Please the matter up to enable him to obtain the case diary.
My lord, page 9, my lord, the prosecution.
No, but when there is an order of coordinate bench, you have to comply that.
Right.
I can't. Yes.
59. 59, my lord.
My lord, item 59, I am in VC, my lord, I may kindly be allowed.
Yes.
Well,
Yes, Mr. Mishra.
Well, lordship's voice is not audible, kindly.
You got the
No, my lord,
Yes,
302
yes.
CD requirement.
See, last date, the direction was to get the CD. CD is
My
now.
lord, charge sheet has been filed under section 306. It's a case
Right,
of.
but but what happens is if the coordinate bench has passed an order, it has to be complied. I can't defy that order, right?
Oh, my lord.
By order dated 3/5/2024, the coordinate bench of this court has directed the prosecutor to obtain the case diary and the postmortem report.
My lord, the charge sheet, I have this certified my associate there. If Lord kindly permit,
Give it certificate.
I am giving a copy to my
However,
friend.
then counsel for the state
The lordship
submits
may
that-
kindly accept the certified copy which I
Yes,
am
yes, I
producing.
am taking that. State submits that he could not obtain the case diary. Mr. Mishra and counsel for the petitioner submits that he has obtained the certified copy of the charge sheet. The same may be filed within 2 days. Advance copy of the same is supplied to the state council. Lease the matter after. So as to enable the state council to obtain the case diary. Yes.
My lordship may give
Comply.
one.
Comply the order of the coordinate bench dated. Who did koilu? Last date. Yes.
My lord, 1 week after. In all cases.
Yes.
My lord, next week, the lordship may keeping
Yes.
to.
Just give 1 week in between next week. Okay. Yes.
But in the meantime, kindly, my lord, appreciate that 306 and she poisoning herself has taken poison. And
No problem. If next time they can't get the case diary,
My lord.
and on the basis of the charge sheet which you have filed, I am deciding.
Yes, my lord. Once coordinated bench are directed, we have to respect.
Right.
Grateful.
Yes.
60, my lord, I am on VC, my lord. My lord, petitioner is in custody since, my lord, 2nd March 2024. And in this case,
My lord.
Yes. Yes.
and charge sheet has been filed under section 506, 500 and 354D of the IPC and 12 of POCSO Act. Custody since, my lord, is 2nd March 2024, my lord.
Okay.
Yes, my lord.
My lord, victim was examined at PW1. He has annexed that. Sorry, my that
Yes.
is 164. But it was
Read the
recorded in
164. C23. Victim is
date of birth of the victim, my lord, in 2007. So 17 years.
17 or 23. Yes. It's not
And the question copy has
sexual
answered.
intercourse also. It's 350.
No, only he has uploaded some nude photos in the Instagram, but no one has seen that photos.
Nobody seen.
And only
63.
Lordship, in item number 63, I am appearing virtually in this matter.
Yes.
Yes, Your Lordship. Lordship, on last date, the Lordship had called for case diary and postmortem report.
Is there?
Yes.
Yes.
Lordship, the petitioner is in custody since 9th of July 2023, Your Lordship.
Allegation?
Lordship, the allegation is that
Rejection on 21st September 23, charge sheet filed on 27/9/23. After
What are the offenses?
my lord, 201, 302,
Offenses.
and 492.
offenses, lordship 302.
Charge sheet filed on?
Charge sheet filed on 27th September 2023.
23rd, 27th September. And when it was rejected?
Rejection 21st September 23. Before our charge sheet.
Yes, after your bail application is rejected, charge sheet is filed. You have to renew the bail application there in trial court, right on. Petition is agreed by the order dated 21/9/2023, whereby his bail plea has been rejected by the trial. Subsequent thereto, on 27/9/2023, charge sheet has been filed. In the changing circumstances, petitioner should approach the court below by renewing his bail plea. Therefore, I am not inclined to entertain this bail application. However, liberty is granted to the petitioner to renew his bail plea before the trial court. If such bail application is moved, the same shall be decided within 15 days. Yes, next.
Gratefully, Lordship.
64.
64 to 302 CDG required.
CD, call for CD, yes.
Short date will be, 64 short date will be.
Yes. 65.
May have been.
Yes.
Custody is business, a ladies matter, but the custody is in custody 18/1/24 manner.
18/1.
24 manner.
CDG required both cases. 65 seats.
302.
No.
363, 370.
Allegation that the informant petitioner was a petitioner and the informant slept in a bus stand matter. A petitioner with his son and informant with his granddaughter matter.
370 capital A.
374. Henias is there, the CDG required. In order sheet itself. Order sheet itself page 7.
Okay, there is an order. Oh, then there is an order, then I can't do it. Right on. White order dated 3/5/2024.
One thing. In the meantime, charge sheet submitted, madam. You move the court.
That's a good idea.
Yes.
Right on.
That observation.
Petitioner is agreed by the order dated 22/3/2024, whereby his bail plea has been rejected by the trial court. Subsequent thereto, on
Arrested.
No, charge sheet filed.
That date is not me.
I have no charge sheet.
Subsequent thereto, the counsel for the petitioner submits that the subsequent thereto, charge sheet has been filed. Therefore, he seeks to withdraw this petition to renew his bail plea before the trial court on the changing circumstances. The present petition is disposed of with the liberty to the petitioner to renew his bail application before the court below. If such application is moved, the same shall be considered within 15 days. Yes. Yes.
66. 66. Can be taken of this matter along with BLAPL 8714/24.
Release the matter along with the BLAPL number
8714/24. Tired of matter.
FR is not with the FR is not.
In that matter, it may be there. Yes.
67. 8714/24.
67. Yes, sir.
May I please your lordship? The petitioner before your lordship is a lady, that too stepmother of a victim girl, is in custody since 9th March 2024.
24.
Lordship.
Yes.
9th March 2024. Your
Yes.
allegation is that the present informant, who is the mother of the
Is
victim,
there?
Yes.
the present informant is the mother of victim, and he is the divorcee of his husband, and the present accused person, petitioner before your lordship, is the second wife of that victim girl, your lordship. By virtue of an order of family court, there was divorce, and because of visiting rights, the victim girl used to come with her grandparents to his house. On a particular date, that is on 2nd January 2024, she has been to her father through his grandfather, and during stay, her stepmother used some tablet on her private part. As a result, there was bleeding and pain.
Yes.
Very easy.
Lady your lord.
You are 30-year-old woman and
Yes, sir.
a small child, you are doing all this.
Thing is that your lordship, I do
Sonography report is there, everything.
there
Sonography
are two
report is there,
sonography
let's say.
report, two sonography report, and both are contradictory to each other. your lordship.
That is separate aspect. It is a well proven. The doctor has said.
And moreover, your lordship,
Inner injury is there, bleeding was there.
twice summons has been issued by the court of sessions, but neither the victim nor the informant are turning up for their deposition in the court below.
For the petitioner seeks to withdraw the petition to.
The custodial interrogation reports are
May I please your lordship? My lord, in this case, the petitioner being a woman aged about 40 years is in custody since 11th October 2023, my lord. And except present petitioner, there is no any member to look after his 11 years son, my lord. And in this case, my lord, the deceased is the husband of the petitioner. And in page number 3, my lord, the 161 statement of the deceased is there, my lord.
Here.
And in once that is my lord Labanidhar Amat. He has stated before the IO that ମୁଁ ଏମି ସ୍କୁଲ ବିଲେମୁଣ୍ଡା ଠାରେ ପାଠ ପଢେ ମୋର ବାପା ମାଙ୍କର ମୁଁ ଏକମାତ୍ର ପୁଅ ଅଟେ ଗତ ସୋମବାର ରାତି 11ଟା ସମୟରେ ମୁଁ ଆମ ପୁରୁଣା ଘରେ ବିନା ତରକାରୀରେ ଡାଲିରେ ଭାତ ଖାଇ ବସିଥିଲି ଓ ସେତେବେଳେ ମୋ ମା ପାର୍ବତୀ ଅମାତ ଖଟରେ ଶୋଇଥିଲେ ଏହି ସମୟରେ ମୋର ବାପା ପ୍ୟାରୀ ଅମାତ ଘରକୁ ଆସି ମୋ ମାକୁ ଖାଇବା ପାଇଁ ଭାତ ମାଗିଲା ମୋ ମା କହିଲେ ଯେ ଭଲ ଲାଗୁନି ତେଣୁ ମୋତେ ଭାତ ବାଢି ବାପାଙ୍କୁ ଦେବା ପାଇଁ କହିଲେ ମୁଁ ଭାତ ଖାଇସାରି ଉଠି ମୋ ବାପାଙ୍କ ପାଇଁ ଭାତ ବାଢି ଦେଲି ଓ ମୋ ବାପାଙ୍କୁ ଦେଲି ମାତ୍ର ତରକାରୀ ଦେଇ ନଥିବାରୁ ମୋ ବାପା ଭାତ ଥାଳିକୁ ରାଗରେ ଓଲଟାଇ ଫିଙ୍ଗି ଦେଲେ ଏହି ସମୟରେ ମୋ ମା ରାଗିକି ପାଟି କଲେ ଫଳରେ ମୋର ବାପା ରାଗିକି ପଲାଇ ଗଲେ କିଛି ସମୟ ପରେ ମୋର ବାପା ଗୋଟିଏ ବାଉଁଶର ବାଡ଼ି ନେଇକି ଆସିଲେ ଓ ମୁଁ ତମ ଘରେ କେବେ ମଧ୍ୟ ଭାତ ଖାଇବି ନାହିଁ କହିଲେ ଓ ମୋର ମାକୁ ପିଟିବା ପାଇଁ ଉଦ୍ୟତ ହେଲା ବେଳେ ମୋର ବାପା ପଛକୁ ଅନାଇବାରୁ ମୋର ମା ବାପା ଧରିଥିବା ବାଡ଼ି ସହିତ ମୋ ବାପାଙ୍କୁ ପଛପଟୁ ଧରିଦେଲେ ଓ ମୋର ବାପାଙ୍କୁ ଜୋରରେ ମୋର ମା ଜାବୁଡ଼ି ଧରିଥିବା ବେଳେ ମୋର ମା ମୋତେ କହିଲେ ଯେ ସେ ବାଡ଼ିକୁ ବାହାରେ ଫିଙ୍ଗି ଦିଅ କହିଲେ ମୁଁ ସଙ୍ଗେ ସଙ୍ଗେ ମୋର ବାପା ଧରିଥିବା ବାଡ଼ିକୁ ଆମ ଘର ବାହାରେ ଫିଙ୍ଗି ଦେଲି ଓ ଝାଡ଼ା ଲାଗିବାରୁ ମୁଁ ଘର ସାମ୍ନାରେ ଥିବା ଜମିକୁ ଝାଡ଼ା ପ୍ରାୟ 20 ମିନିଟ୍ ପରେ ଫେରିଲି ଘରକୁ ଫେରି ଦେଖିଲି ଯେ ମୋର ବାପା ଆମ ଘରର ଭିତରେ ଥିବା ବାଲି ଗଦା ଉପରେ ଶୋଇବା ଭଳିଆ ପଡ଼ିଥିଲେ ମୋର ବାପା ସବୁଦିନ ମଦ ପିଇ ଭଲ ଅବସ୍ଥାରେ ନଥାନ୍ତି ତେଣୁ ମୁଁ ଶୋଇବାକୁ ଆମ yes my lord
one sectoral something there.
Investigation section.
Who has assaulted him?
That is the unknown.
Completely drunk.
Because
he was attacking the wife.
Before the time, only he saw that one, but after that.
You are in custody since?
My lord, since 11th October 2023, my lord.
11, 12, 23.
Yes.
11, 10, my lord.
11, 10, 23, charge sheeted on 7 February 24.
February 2024.
I'm allowing. He is a lady. What will he do?
Yes, my lord.
What will he do? Rather, the husband who is the deceased.
Yes.
He wanted to. He attacked this lady. The son has seen. This is a reverse story.
Yes.
The lady what to do? You know, petitioner is accused and so on, so on. The allegation against the petitioner is also. The vital witness to the occurrence is the son of the petitioner, son of the petitioner. The petitioner, the deceased was the wife of, deceased was the husband of the deceased. In the on the date of incident, 164 the statement of the son of the petitioner under 164 CRPC has been recorded by the police. He initially stated that on the date of incident, the deceased picked up quarrel with the mother on the silly issue of not serving vegetables, not serving serving the meal without vegetables. On that, the deceased came with a stick and started attacking his mother. The mother got hold of the deceased and pulled up the lathi and gave it to him to throw it outside. He thrown the lathi by pulling it from the deceased and went away to attend the call of nature. By the time he came back, he saw that his father was lying near the house. He also stated that the father has been drinking heavily. Apart from the evidence of apart from the evidence of the said witness, who is the son of the deceased and the accused, there is no other evidence which is coming forth in the charge sheet. The petitioner is a 40-year-old woman, and it appears that he has been suffering at the hands of the deceased, and the deceased has been harassing the petitioner, and rather on the date of incident, the petitioner attempted to physically assault the present petitioner. There is no other evidence which is illuminating on the record to implicate the petitioner. Regarding to the nature of evidence and the fact and nature of evidence and the custody of the petitioner since 11/10/2023, I am inclined to enlarge the petitioner on bail. Accordingly, the petitioner is granted bail. Yes.
70. Greatly obliged, my lord.
Yes.
My lord, the petitioner are in custody since 17/9/2020 for the offense.
24.
Sir,
CD is not with me.
CD is there, sir, or charge sheet is.
No, CD hasn't come. Wait. Persons to the.
Sir, there are only 8 days to go.
1 minute.
Complete 1 year, sir.
1 minute, sir. Persons to the order dated 6/5/2024 passed by the coordinate bench. The case diary has not yet been received by the prosecutor. Hence, 1 week time is sought. Accordingly, leave the matter after 1 week. Yes, sir. You had some matters waiting.
Sir.
2 o'clock, I don't think. You please give your convenient date, because I'll tell you what our plan is. It's not my plan; it's a plan of all of us. There are a lot of bail matters. If I'll get little leverage so that I can attend to all the bail matters. Thereafter, I'll start hearing these matters. So I started listing more bail matters so that at least you please give a convenient date to him. He will be in touch with you right now. And please.
Mathematically, it will be proved in less than 6.
I know that. See, if I get little time, but not hearing the regular matter, at least I can attend to all bail applications. Once all bail applications are attended, thereafter leisurely we can, attend to this. That's the idea. Okay. Please take a particular date from the sir and thank you, sir. Thank you. Only 30 matters. Yes.
If a lordship permits me, my lord.
119, my lord. I already filed in 18/6, my lord, for opposite party, my lord. 130,
Which petitioner?
petitioner 130 enact matter, my lord, enact matter. Petitioner, my lord, taken time, my lord, first hour, my lord. Matter was adjourned to 18/11, my lord. Short date, maybe.
That's
Already
the problem. If you
my
mention
name, my lord, is not reflected in cause list, my lord.
name should be reflected. We'll see.
Short
I'll try to
date.
report.
Yes, right.
Yes.
Lordship, my lord, I have a small prayer, my lord. My lord,
Yes, sir.
my lord, in item number 130 of the main list, my lord. Your lordship had directed this case to be taken over at 3 o'clock, my lord, yesterday. But it did not, my lord, it is that Bangalore police matter, my lord, who was being arrested here, locally in Koraput, my lord. And there,
Let it be there in the list. Let it be spillable to next day. That is on Tuesday.
Malad, can I pray this to be taken up on 10th Tuesday itself, Malad?
10th, huh?
10th is Tuesday, let it be there.
Yes, that's what. Let it be there. Let it be there in the list on 10th. Huh?
But,
130. This is
130, Malad.
130. 130.
In the weekly list, Malad. If a lordship fixes us up.
Huh? No, we have not fixed any. It's a weekly list, huh?
Malad, what I pray, if it can be taken out at 3 o'clock, Malad. So it can be taken up, Malad. Otherwise, below in the list, it cannot be taken up, doesn't reach, Malad. And the trial proceeds, Malad, that's the whole problem. There has been no stay, Malad, that's the whole problem, Malad.
We'll see. I'll see on Tuesday what can be done, huh? In the morning. Okay.
Quite right.
Yes.
With pardon, item number 135, my lord. Item number 135 fixed for 2 p.m. today, your also lordship. My lord, that is a vigilance bunch matter, your lordship previously heard our side, and the vigilance council.
Let us see whether I can reach there or not. If I can reach, then I'll hear it.
My lord, this matter pending since long, your lordship.
What do you want? You want hearing or you want adjournment?
Hearing, your lordship. Only
So
hearing.
wait. Why are you wasting my time now? Wait till I may reach there.
135, my lord.
Yes. Wait. Next. Yes.
One compromise matter, my lord, 128. Petitioner is present and father of the offender is present.
1 minute, one pass.
Oh, sorry, man. Sorry.
My lord. Yes, my lord.
The petitioner and the opposite party amicable settle
Yes.
and file a joint affidavit, and both are also present before your lordship.
What is the offense?
My lord, 307.
294, 307,
Injury? Just see the injury. The injury report. Investigation is going on.
No, my lord. Charge sheet submitted, cognizance also taken.
Where?
I'm annexed the order of cognizance at annexation number 2.
Show me the injury. Nature of injury.
Injury, my lord, simple, but I don't have.
My lord, there is no fresh
Show me the injury report. 307, I need to see injury even if you settle the dispute. Injury, whether vital part or not, what did you offense of weapon you have used?
My lord.
Which part of the body the injury caused, whether it's simple or grievous?
My lord, injury simple, my lord. But
show me.
अच्छी की पकड़े नहीं पकड़े नहीं
You file a cognizance order, you say that quasi. without filing anything. File all the documents, right down. Then counsel for the petitioner seeks to place on record additional document to substantiate his case. Let him file the additional document. Please.
এটা বকালতনামা আছে অপোজিট পার্টনার টু অ্যাপিয়ার করছুতে
This is not that in any case you can come and say that we will settle. I'll quash it.
My lord,
I have to see the nature of grief,
my lord,
injury and all.
my lord,
Not
injury
that,
report I
take on record. So and so enters appearance on behalf of opposite party number 2. Have you implicated the
my lord,
injured
my lord,
as well
as
as
the opposite part number 2, my lord.
and who is the informant? Same.
It's same informant and injured and
It's all right. You file the document. Let us see.
my lord,
Next.
can you fix it date?
He'll fix it.
Okay.
Next. A short date he'll give. Don't worry. 9. Yes, sir.
The petitioner by the time of alleged occurrence was the SDO electrical alerts.
Yes.
In front of other in came contact with so far the stay aware of the electric pole.
You are challenging cognizance, right?
Yes,
That is
ma'am.
the year 2010.
And they are succumbed to injury, lordship. Same set of-
2010
I'm
cognizance.
coming here. Same sets of allegation and FIR was registered. In the
What
FIR,
is the stage of the trial? You
the
tell me.
police has here, police has been said to be that it's a false case. And it's submitted a final report.
Whatever. Cognizance
They
is
are
taken
appro-
in 2010,
No,
sir.
thereafter protest petition is filed by the process of protest petition. Cognizance been taken, is
I
process has been
understand
issued.
that. I know. I have read it also.
I am not only filed this application quashing of the cognizance, but also entire proceeding also, lordship.
What is the stage of the trial? I'm asking.
That is not been real, lordship. It started, lordship.
What is the
It
stage?
is not been
The
started.
order which he has filed another CRLMC, my lord. That is the order. 1663 of 2015. It was disposed of on.
You sought permission to argue all these points before trial court.
The stage of framing of charge, lordship say.
You have said that. Now you are challenging cognizance.
By that, lordship, we have
Petitioner
no
had challenged
negligence so far our part is
29
concerned.
29/1/2010, whereby the cognizance for offence punishable under section so and so has been taken by the court of DJM
Veeramitrapur,
Mahajanpur on the protest petition filed by the opposite party number 2 informant.
Veer Maharajpur, lordship, Veer
Earlier, the
Maharajpur.
petitioner had approached this court by filing CRLMC number 1663 of 2050 and by the order dated 14/10/2022, the said petition was disposed of by passing the following order. Since the cognizance of the offence has been taken way back in 2010, and earlier the petitioner had already approached this court and took the liberty to urge at all the points before the trial court. I am not inclined to entertain this petition, hence the same is dismissed. Next.
Obliged.
Yes.
The lordship that may say to Veer Maharajpur, lordship, not
Veer
Veeramitra.
Maharaj. 128. Yes. What is the offence, sir? Offence?
Our matter 128.
Huh?
128, my lord.
Offence.
Yes, offense 498A, my lord.
498A.
Yes, my lord. And in the meantime, matrimonial suit has been disposed of. And as per my lord's direction, the petitioner is present. And opposite party number 2's father is also present.
498A. At the instance of opposite party number 2, FIR number so came to be registered against the petitioner. Petitioner is the husband.
Yes, my lord. Petitioner is the husband.
of opposite party number 3.
Yes, please.
They are separated. Where is that decree?
Decree is under annexure.
The marriage between the
Jointly, my lord, they are staying jointly, my lord. And the wife is at an advanced stage of 6 months.
They started staying together.
Yes, my lord. Yes, my lord. That is the observation of the London family judge.
Parties have settled dispute.
Annexure 3 at page 21, my lord.
The opposite party number 2 has filed an affidavit dated 4/9/2024 inter alia stating as under 3, 4, and 5. 3, 4, and 5. The petition 3, 4, and 5. The counsel for the petition the parties have now started staying together, and all the dispute amongst amongst them has already been settled. The petitioner, the opposite party number 2 is at the advanced stage
Yes, ma'am, of 6 months.
pregnancy. Therefore, she wants.
She has also filed an affidavit to that
She
effect.
doesn't want to proceed with the present case against her husband. Hence this petition. The petitioner and the opposite party number 2 is present.
Yes, ma'am. Father is present.
Father is present.
Yes, ma'am.
Opposite party.
2 has filed an affidavit, my lord.
You
That
have
she is
filed
at-
her Vokalakama.
Yes, my lord.
Opposite father of opposite party number 2 is present.
Yes.
The opposite party number 2 is not present today in the court, owing to the fact that she is pregnant, heavily
Yes.
pregnant,
Yes.
heavily pregnant.
Yes.
The opposite, the petitioner and the father of the opposite party number 2 who are present are being represented by their respective counsel and being identified by them. They have also filed self-petition for copy of their Aadhaar card, which is taken on record to establish their identity. The joint, the petitioner and the opposite party have also filed a joint affidavit dated 10/5/2024, reiterating the same state. The opposite party number 2 has joined with the petitioner, praying for washing up
Yes, ma'am.
the FIR in view of the development which has taken place. Regarding head to the aforementioned and relying upon the judgment of Gyan Singh and so on, so subjecting the petitioner to rigors of the trial would be a futile exercise. Therefore, the FIR so is quashed. Yes.
71.
71. Yes, 71.
See, as well, order dated 6
May I
May
please?
2024. IO is there. It is
6.
order dated
Notice
6
was
24.
issued
6
to
May
the,
2024.
Extra copy have been given.
yes,
Let's see. Victim is appearing through.
The petitioner is in custody since 23/9/2023,
23,
9,
9, 23.
my lord.
Yes.
For offense under section
Hmm.
341, 294, 506, 324,
Yes.
326, 307, 21, and 34 of IPC.
Yes.
The entire incident occurred after taking of liquor by the petitioners and others.
Charge sheet filed.
My lord,
Charge sheet.
charge sheet filed on 25/1/2024.
25,
1,
1.
2024.
Okay. What are the offenses in charge sheet?
Charge sheet, my lord, that is,
307.
my lord, 307.
Injury.
My lord,
Injury.
Grievous in nature.
one grievous, 3 simple injury.
Grievous in nature.
One grievous.
1 grievous, 3 simple.
3 simple.
What was he holding?
Knife.
Abdomen was the abdomen injury is the grievous one.
Knife injury.
Knife.
Then you have caused that.
My lord?
You have caused that.
Yes,
Yes.
my lord.
What about the other accused person?
Other request, my lord, I don't have instructions.
First you apply for them, they should get bail.
My lord,
Parity you get. Why are you doing it the reverse way? You get rejected and the other people will also get affected. You are the guy who has given the grievous horse.
My lord.
Wait, I'm
My
just
lord,
thinking.
1 year, my lord. He's
Maybe
custody.
the people, the
My lord, Lord may consider. 1 year, my lord. 307, only one grievous offense, my lord.
2 antecedent is there.
Two
antecedent. Lord may consider any
But
condition.
in
my lord.
other one,
Any condition, what about the other accused person?
other accused is not filed
Other
because they
accused
have
are behind custody.
6 antecedent for that
They
one.
got bail.
No, my lord.
They should get the bail, not you.
But they have the 6 and 7 antecedent.
Or they have 6.
Yes.
Yes, for that only.
Lord, I'm the better footing. Lord, consider, my lord.
CD is there?
Yes, sir.
CD is there?
Lord, any condition, my lord.
September. 1 year already.
Yes.
He has been discharged.
Yes, my lord. He has been discharged from 14th of October.
Charge sheet is filed on 25.
After 1.5 months, he was
25
at the
one.
hospital, let's say.
Record has been committed to
1.5.
1.5 months he was in the
Yes.
hospital.
my lord. Initially, he was referred to
Lastly,
Bukla, then
from Bhimsar, he came to SCB. SCB operation
on
made, and after that,
14. Now the injured is healthy and hearty, and he's doing his usual work, my lord.
You implead him and call him. I'll see.
Lordship may consider any condition, my lord.
Wait for another 10-15 days.
Lordship,
Advise the other accused to move application.
Lordship may any condition, my lord.
Wait,
1 year, my
because
lord.
1.5 years, 1.5 months he was in hospital.
Well,
I don't know. Nothing is coming forth. You show me the medical evidence?
Yes, it is there.
When he was admitted, when he was discharged?
Let's say enter document my lord here.
What are the nature of injury? Have you checked up?
Yes, sir. Yeah. Also with CD it is there. The
161
incident.
Have you recorded
for better
statement
yes.
of
he was shifted to SCB for better management.
you read out the evidence of the injured evidence. Evidence of injured. You have?
Yes, yes.
Read it up. He was referred to Bulla Hospital,
my lord,
because the seriousness of the injury.
Then to SC Medical.
Then to SCB Medical College.
କୁନ୍ନୁ ଦାସ ମୋଟରସାଇକେଲ ଓହ୍ଲାଇ ହାତରେ ଗୋଟିଏ ଛୁରୀ ଧରିଥିଲେ ଓ ସେ କହୁଥିଲେ ଆମ ଜୀବନରେ ମାରିଦେବୁ କହି
The broken knife are there in leg. It came out, which is in the seizure list. It is there.
ଲିଙ୍ଗ ସାହାକୁ ପେଟରେ
After
ଘୁଷି ଦେଇ
15 days.
my lord,
Wait, he was brutally attacked by you, and he was admitted to hospital. Thereafter, he was referred to Burla Hospital. Thereafter, it was so complicated. Again, referred to medical SKC Medical College. 1.5 months he remained in the hospital.
My lord.
Then he was discharged. Very serious injury. Yes. After 15-20 days.
After?
Yes. 72, 74.
74.
Yes, sir. Custody.
Custody since my lord. 24/4/2024.
24/4/2024.
2024.
Okay. Offense?
Offense under section 420.
420.
420, 294, 506, 34.
420. Yes.
Your lordship.
Case is there?
Yes, sir.
Yes.
Your lordship, kindly type the BLPL number 5799 of 2024. Your lordship 5798. 99. Better move some detail lekhi and this is the matter. Your lordship has.
How many bail applications are there? What is the role of all these people?
My lord.
One after another you have.
My lord, I have. Your lordship can have a glance to the affair.
No, charge sheet has been filed. Read the charge sheet.
My lord.
Read the charge sheet.
Charge sheet, my lord. 420. My lord, the
20
allegation
person, he has taken 1 crore and some.
in 2015, my lord.
And
The informant has given on the first instance 10 lakhs to me.
all are
Then-
for the job purpose he has taken them.
No, no, job.
But last occasion was something.
You promised to give the job.
No,
Yes.
no. In
Job as well as the license for the
5799, my lord.
civil supply.
5799. BLPL.
You are not pressing other.
ନାଇଁ ସେଇଠୁ ଆରମ୍ଭ ହେଲା କଣ ପାଇଁ ହ୍ୱାଟ ଇଜ ଦି ମାନେ
Yes, I am there. 5799.
ମାଇନର 5799 2015 number your lordship paragraph 2 page 12
Yes. What is this? You have.
Madam, I have given that death chart, my lord. On 15/3/2012, my lord, the present petitioner has invested.
You got that list update?
Yes,
You- Give it to him.
On 15/3/2012, my lord, the petitioner has invested some money in the informatics company, my lord. On 7/12/2015, the petitioner has filed one complaint petition before the Lord JMFC Shoro bearing dated against the informant. That she has not returned that money, my lord. My lord, on 25/9/2023, my lord, your lordship, I have lodged an FIR before the concerned IAS. On that issue, no. Another issue, some tenants have created disturbances, so I went to police station. The police officer misbehaved me. For that reason, my lord, I have approached the Human Rights Commission on 19/2/2024. And after that, my lord, I have also filed a CLMP before this honorable court on 18/3/2024, my lord. And on the basis of the direction of this honorable court, I have filed a complaint petition. That is 22.
Against that police people.
Yes, my lord. After the 22/3/2024, my lord, it is start from 19/2/2024. Human Rights Commission also issue notice to the concerned IIC, and when I lost the FIR on 22/3/2024, my lord, your lordship may kindly have grants to the, I have written the last page.
Against the petitioner,
हाँ,
so many,
6टा केस है
seven cases.
सेवन केसेस सब गुड़ा देखो 3/4/2024, 28/3/2024, 1/4/2024, 24/4/2024, 26/4/2024 और 8/3/5/2024. He has collected all the informant, my lord, and lost this affair against me.
Petitioner was arrested and forwarded to the court. This is against you.
Yes.
This is Ramesh.
Padi.
What about the other people?
Other person, my lord, two cases. One case से एइटर ए आली जो फर्स्ट केस टा आपन को देखुची 5799 रे एथरे एलिगेशन दानार किछि नै खाली मु चिन्ह हेइथिली बोली अछि.
No, how many cases here?
Say, I have given, my lord, that
Ramesh Chandra Padi first item 5813.
5813. My lord, 5813 and
This is another FIR.
Another FIR. So say for 1960, 468, सब say
5.37.
NI Act case मध्ये ମୋ ନାରେ pending ଅଛି.
See, check has been transfer amount. Check transfer amount is there. All these proof of amount
But
he has taken the amount.
In the 5799,
yes,
whatever he has said,
yes,
is it correct?
That I have to ascertain.
Now, all of a sudden, after the police officer was implicated by him for in some cases, he files 7 cases. All cases are after this date.
I am not on that way, lordship. I am on all these persons who has filed the FIR with the documents that they have paid the amount. I am on that.
I am not able to understand why have you filed why these two cases are tagged together.
सब एगा मोर नारे सब तो सही गोटे पीएस रे
लक्ष्मी नारायण
हां गोटे 16 पीएस रे एगा सब तक
एक लक्ष्मी नारायण दास
मतलब पिटिशनर नंबर 1 लक्ष्मी नारायण दास my lord, another petitioner, my lord. Ramesh Padi, I am placing, my lord, all the issues are Ramesh Padi.
You do one thing, take into consideration this, prepare a chart in which case who is accused and what is the period of custody, what is the nature of it. And I am putting it witness.
I have to ask some from
all the papers you have. I could have done it, but it is wastage of time. So therefore, you please assist me.
I have to
if this is the correct time, going to grant the bail.
This is only for 5799.
Shall I allow 5799?
No, I am not on
to begin with.
I have said that today he has supplied this one, and here CD has not come.
You prepare a chart and give me.
Yes.
Wednesday, Thursday, I am keeping next week. Because all the five matters can be disposed of.
Because here 579 CD is not with me. For that only I am asked to
see the allegation, ask the IO to come and do it.
Yes.
Next week.
Friday.
Thursday. We can dispose of 4 matters. Therefore, I'm saying. And the after all, what is the allegation? 420. All are documentary evidence. Why should they be in the custody? Charge sheet has been filed. That itself is a ground for letting them out.
Not in all cases. There is 2 cases charge sheet there.
You tell me.
charge sheet
That is again.
I have not got.
So, verify if charge sheet is filed, it is a case of 420, and this is the checkered history they have. Then all are documentary evidences. Why should they be remain in the custody? Wednesday, Thursday.
For that only I was asking.
No.
Next Monday, if you are there, then not.
आसु गुरुवार आसु से जदी डिफिकल्ट हो त
फ्राइडे कर दो टाइम लाउट से भूली वाली जीवा और
प्रॉब्लम
फ्राइडे कर दिया फ्राइडे ओके
नेक्स्ट फ्राइडे
फ्राइडे 13 not good day
all are good if order will follow all are good
76
may I please, Lordship? Lordship, this is the case under section 420, Lordship.
420.
The petitioner is in custody since 8th of June 2024. 8th June.
My lord, before going to that, my lord, yesterday they have case mentioned, my lord, before this court, my lord. There, my lord, they have I have not the IA, my lord, but in fact, my lord, thanks to our master, he informed me that this case will come toward today, take instruction, my lord. But in fact, my lord, the petitioner belongs to Hon'Ble. His address is, my lord.
Interim bail. He's asking for interim.
Yes, listed for interim bail.
Oh, the wife is pregnant.
My lord, what happened in this case, my lord? The police, my lord, the Chowlaganj police, Cuttack police arrested the petitioner, my lord. He's behind the bar. But in fact, in the court, he belongs
You
to
need
that
time to verify.
My lord.
Time to verify because your wife seems to be there.
Hon'Ble, that's your
Hon'Ble. So they.
And the IO, my lord,
And I'll put it when Tuesday.
Wednesday.
Because see,
What I pray, Lordship. What I pray, Lordship, if subject to Lordship.
Yes.
Charge sheet has been filed. If a Lordship may decide the case, then it will be minutes. On merit also.
Let us see, because it is 420.
Lordship, that is what I'm saying.
If he's entitled to regular bail, why should we get into all this thing? Entitled to regular bail, I'll grant regular bail. Forget it to this thing. Let us see.
The petition,
my lord. Then its serial has not come, my lord. On for the IA, my lord, this case, my lord, listed, my lord. Chronologically, his serial not come.
So, all right. If he's entitled to bail, why see, for interim order, I will have to spend 10 minutes. Within 10 minutes, if I can decide, it's nothing like that. Why unnecessary quoting? Just see if we can do it.
Lordship.
What are the allegations?
Lordship, I'm placing the allegation.
How much you have cheated? You tell.
1,30,000. My lord, is the amount. What has happened in this case? The informant is a lady. She was in need of some loan.
Why don't you give?
Lordship, I'm coming to that. The gold ornaments, I have taken the gold ornaments from the informant and deposited in a bank and took that money and did not return the money to the informant.
Okay.
In the meantime, the charge sheet has been submitted. The gold ornaments has been recovered from the bank and returned to the informant. And the bank loan amount has been, my lord, secured. I have while I was in custody, my family members have given I was having a new two-wheeler. The bank has taken it. The custody has been taken. Bank has no issue regarding it.
Exchange for the gold you have given the
Lordship.
vehicle.
Lordship.
What else?
Charge sheet has been filed.
What happened, my lord? So for the IO, my lord, there are two criminal antecedents against petitioner.
Two criminal antecedents and not of similar
nature.
That is
Jajpur PS case, my lord. There are two criminal antecedents against petitioner. And the IO, my lord, though I have not gone through the since
I'll put it Tuesday, Wednesday. You forget about that. You get instruction. That's a different story. But I think he is entitled to regular bail.
IO, my lord, when I contacted the IO, I said, "Oh, that fraud man." that is in my mind, my lord.
Okay.
You had committed so many persons, my lord.
You are representing a celebrity.
No, Lordship.
Wednesday, yeah? Or let's take it up. And focus on regular bail. Focus on the regular bail. If we is entitled, we will give grant. Yes.
77.
May I please, madam? Here I have filed application for modification of 3 conditions which has been imposed by the Honorable Court, madam, while granting the present petition on bail, madam.
Modification of which order?
3 conditions, madam.
Which are the orders?
Madam, may she kindly have a glance to the order dated.
Which one? Okay.
482.
Granted by
Madam Justice Das, madam.
You have to go to that photo.
Not there.
Operating demands,
no, my lord is
coordinate bench has granted.
No, my lord is now retired.
Huh?
My lord is retired. Not my lord Justice Das.
Lordship, previous.
Previous.
He has got the modification once. Again, he is asking the modification.
My lord Justice has already retired.
There should not be any relax to such as a person.
Huh?
There should not give any relax to such.
Merit my lord is saying that.
I'm not on merit. Where was that order?
Madam, see 4/8/2017.
No, there was an order that is to go to the concerned bench, the judicially.
Yes, it was placed. It was placed before my lord Justice, Chief Justice, and thereafter.
Is it marked to me?
Yes, madam. My lord.
Now it's marked to me.
Yes, yes. That's why it is before my lord.
Marked to me, then I'll have to deal with it. To me? Is it marked to me? Just check it out. Notes. Where is it?
No.
It's not marked to me.
That's why it is before it was before matter justice.
Don't. Huh? Huh?
No,
it's not marked to me.
No, it was before matter justice Gori
But
Satpathy.
how are you sure that it is marked to me? You are making a statement.
No, Madam, can I appreciate?
Without knowing, how are you making that statement?
These
things are very.
No. Because of the fact it has been marked.
I'll believe it and pass some order. Then
I don't.
Subsequently, I discover that
it is Malad. Malad has initially said that whether justice here does it was my submission. Malad has retired.
But after
And
retirement,
and thereafter, yes, thereafter because of the fact that it was also Malad Justice Satpathy, and I also filed application mentioned there, and after the roster changed Malad, now it is before Malad. So it has been marked. Malad may see the previous order.
Right. Assignment, which is assignment?
By default, it has been
The petitioner has moved the application for variation of the
page 49.
49 of
What you can say? It's an
Page 77, page
49. 49. Show me what is 49. Where is 49? What are you trying to show me? Which one is 49? Huh? Give it. Has it been marked to me?
Not exactly.
Huh?
Some order is there. Not exactly marked.
What are the conditions, by the way?
Yes, ma'am. Three conditions has been imposed by the honorable court while granting bail. The three conditions out of 7 conditions, 3 conditions I prayed for waiver, madam. Clause number 3, whatever be his place of abode, stay, he shall not allow any devotee, follower, or any news media persons or any super sympathizer to congregate before him for any preaching,
Wait, the petitioner has moved the application for modification of the bail condition imposed by the coordinate bench of this court by the order dated
4/8/2020.
The matter is listed before this court for modification of the condition.
3 conditions.
3 conditions. Since the condition was imposed by the coordinate bench of this court, judicial propriety demands it should be placed before the Honorable Chief Justice for assignment to the concerned bench for modification of the order, modification of the bail condition granted by the coordinate bench. Therefore, place it before Honorable Chief Justice for assigning the matter to appropriate bench with this appropriate bench. Yes, correct. See, these are very sensitive matters. If it is marked to me, then no problem.
Right.
Yes. Next.
78.
78.
May I please, your lordships. My lord, in this case, the son and daughter-in-law had lodged the affair against the old parents, my lords. That case, my lords. The
73, 63. Yes.
My lords, the welfare committee report says that the allegations are false, my lords, and
Son and
son and daughter-in-law, my lords. They are staying abroad, my lords, now. They are not pursuing, and these are old parents, my lord.
What are the offences?
498, 323, my lords. The allegations.
98A.
Yes, my lords.
By the
Wife and
daughter-in-law against the
old parents, my lords.
Hello.
Well, the allegation.
Notice could not be served on him since he residing abroad.
But they filed a engagement against the parents. I'll quash it. Quash it. Give a written submission.
My lords.
Reserve the judgment. Read a
Written
give a
notice.
written note
My lords.
and narrating all this.
My lords.
And it should help me, not add to confusion. Okay.
But one thing, notice not served, that may be taken.
That I'll write it. Notice was not served. The petitioners, the opposite parties are the, where is that opposite party number? Where is that opposite party? You have not implemented opposite party.
Initially, they were not made, my lords, but the informant was served a notice, my lords. Earlier order written in informant.
You have not implemented.
But they were served a notice, my lords. The Honorable Justice R.K. Patnaik had directed to serve a notice, my lords, to the informant, my lords.
Where is the service report?
Noting there. Noting there.
Noting is there, my lords.
Noting there.
The opposite party number, how many opposite parties? We should file a amended memo parties if they are implicated. It's the whole difficulty. People don't do proper work.
My lords, direction was given.
Somebody will take a certified copy of the front page
My lords.
and file it in the appellate court.
Then I'll implement my lords thereafter, my lords.
And the impression will go that without implementing, things are going on. Without implementing someone, how notice could be served? They are not even party to the proceeding.
To the informant, it was served, my lords.
Where is that? Where are the party? They should be party to the proceeding.
For that, the notice return, my lord. Unserved.
Which address? We don't know the address. We know nothing because no name is here.
The affairs address, my lord. The informant.
How do I know in which address it has gone? Unless they are implicated as a party, unless you disclose their address. Right. Though efforts were made to serve the informant in the present case, but neither the informant and who all are they?
Informant.
Who is the informant?
So the daughter-in-law.
Son-in-law, daughter-in-law.
Daughter-in-law, my lords.
Son-in-law has nothing to do.
No.
Son-in-law is not even accused.
No.
The informant has not been implicated in the case. Legal counsel for the petitioner seeks leave of this court to implead the informant as opposite party number 2 during the course of the day. Issue notice to opposite party number 2, written rule within a week, least after 2 weeks. See, this is the reason I would have allowed it. And it is written addressee out of the country, hence written to sender. Who is where is the addressee? There is no party. Addressee is out of country. Where is the who is the addressee? Where is he? Show your petition. How things are moving here, I don't know.
In the FIR, my lords, the address is there, my lords. So that address we have mentioned, my lords.
Do it.
Better file proper address. Parents are there.
Proper file a amended memo parties. Right now, go and type it out and place it on record. File process fee. It will not be served. I know. But on record, it should reflect those things.
Our parents' house, if the server, they may instruct intimate to the intimate.
So both the address, permanent address and present address, both the address you give. And let notice go. Thereafter, I'll quash it. Okay.
79.
Do it right now.
It's an application under 482 for quashing of FIR minutes. Initially, the FIR was registered under 376(1), 417 and 493 minutes.
Final report file.
Final
No,
report file is under the section 417 and 493, both being non-cognizable offense, and charge sheet has been filed and cognizance has also been taken, my lords. If I come to the series of allegations, my lord, according to the victim, my lord, the series of incident happened in 1994 till 2020 minutes. Her allegation was while the petitioner.
Have you served?
Lord, I've made a party.
But notice has not.
Not issued.
Issue notice to opposite party.
The first statement. This is the first statement.
Issue notice to opposite party. No? Let us see. Yes. 80.
Obliged.
May I please?
Yes.
Kindly have a glance. Order dated 12th of this month. This is a case of 376, my lord. And the notice issued twice to the informant opposite party number 2.
Here.
And she didn't turn up. Through IO also notice has been served and it is sufficient. Your lordship granted an interim order to up to 1st of this month for surrender, my lord. And in this case, the 3 petitioners are there. Petitioner 2 and 3 are on bail. Only petitioner number 1 is not on bail, my lord.
So what do you want?
Modification, extension.
Extension of what? Time.
Time.
For surrendering.
Yes, ma'am. And the second thing is that 2 and 3 are on bail. That is not necessary to be surrendering.
But this petition is for quashing.
This petition was quashing, it is disposed of. It is disposed of. Because of the victim girl has not.
Which is that order? To me?
My lord?
Okay, this order. Huh?
12th.
You want extension of time. Have you moved an application?
Yes.
Okay. Which I?
2425.
2425.
My lord.
For the on the reasons stated in the application, 2425. The extension of time for surrendering appearing.
My lord, one thing I have to submit, my lord. In this case, in the cognizance order, it is stated that the NBW issued earlier be executed and date fixed for production of the accused. But previously, no NBW issued against the technical error in the record, my lord. May I pray by extending 3 months, trial court may proceed for trial, my lord.
No.
But
appearing before the court below and availing the remedy under law is allowed. The petitioner is directed to surrender of the
8 weeks. Laborer and working outside of the state.
How much time you need?
8 weeks, 2 months. 8 weeks.
8 weeks. August I had given.
Yes.
Okay, September, na? 15th October. 15th October.
Another thing, my lord, the attendance of the opposite party number 5 victim may be ensured while considering the bail. Because the affidavit is there.
One petition. Do you have any other dispute anywhere in the world? I will address that also. You tell me any other dispute anywhere world, I'll address. What is the petition? What are you asking? What application you have moved? You have moved an application for extension of time to surrender.
Yes,
one after another you are seeking. You do this, you do that.
No, an averment is there, my lord.
Averment you make whatever averment. I'll reject the application, then
No,
everything will be okay.
Only extended.
Extend till 15th of October to surrender and everything. Will be. Yes.
81.
Yes. Yes, sir.
The name of the petitioner was not in the counter FIR.
Yes.
And also not in the charge sheet. But after protest petition filed, he was charge sheeted.
The material might have come on record.
The material, no. The fact is, they had a compromise of the court in the village committee. So they want to close.
You are
the case.
Basanto Das, huh?
My lord.
Come to the complaint. Protest petition.
Of the court.
Come to the protest. Already compromised. Issue notice. Let counsel for the petitioner submits that in the present case, he has his client have settled the dispute with the opposite party number 2, or issue notice to opposite party number 2 returnable.
I is there.
You bring them, can you bring it on Monday, Tuesday? I'll do it. No stay. You bring them. I'll pass it. No problem.
No, party is in Calcutta now.
Well, then 2 weeks, bring them.
4 weeks, my lord, may be allowed. 4 weeks.
Yes. Next. Online they can appear. Why to come? This? Yes.
One matter was specifically fixed to 2 p.m. for hearing. So it may be taken off some other day, well, today.
That's it.
Month of October, I was asking my learned friend, after vacation, it is pattern matter.
Parted, I know. Parted.
Keep it on Tuesday, madam.
1 minute, sir. 1 minute. 1 minute. 1 minute, Mr. Das. Wait. I'm taking
Maybe
1
All right,
minute.
madam. All right.
in this month, on 27th or 26th.
27, 26. Very good. 27th last Friday. That
25th,
Madam?
25th at 2 p.m. or 3.
5th October. That is a working day. You come Saturday. 5th October. That's the best time we can spend.
First case.
5th October. There won't be much case. We can do it.
First case, pattern matter.
Parted. Okay. 5th October. Okay. Yes, Mr. Das.
Your Lord, you will keep it Tuesday, madam. And since I am suffering, my lord, I come to my residence, madam, Sambalpur. Therefore, I am unable to.
Sorry, I couldn't follow you.
My lord, your Lord, you will keep this matter on Tuesday, madam, on 10th.
No, if you want adjournment, you tell me. I'll give it. Don't fix
My
the
lord,
date yourself.
you know, madam, I am not feeling well. I'll come to my residence, madam.
But the petitioner is not well, so therefore he seeks an adjournment.
Keep it on Tuesday, madam. Your Lord, you will keep it Tuesday.
I will see what can be done. 82 adjourn. Yes.
83.
May it please, your lords. 83, my lord. Previously, the twice issued notice to the opposite party number 2, my lord. And the status of the tracking report is flag C. Twice issued the notice, my lord. Flag C is the postal tracking.
Answer notice returned from OP2.
Delivered. Item delivered.
Item delivered. My lord. Previously, my lord, your lordship heard this matter. The petitioner is working with the naval unit of Bhavanipatna, my lord. Here, the prayer is that, my lord.
You are challenging what?
The proceeding, your lordship.
Okay.
Initially, my lord, the complainant lodged a complaint under section 294/506 of the IPC. Meanwhile, on 23rd April 2022, the police filed charge sheet, that is 294 and 506, my lord. My plea is that, my lord, plea of alibi, because, my lord, on that day, that day of occurrence, I am not there, your lordship. Page number 14 and 15 may kindly have a glance, your lordship. Page number 14, 14 and 15.
Yes.
The movement order of the naval unit, your lordship. Since 30 March 2022 to 4th April 2022, I am at my naval unit, your lordship. I am working there, my lord.
What is your name?
My name is Manoj Kumar Mahapatra, your lordship.
Oh, you were asked to proceed to duty. Okay.
My lord.
You have proceeded, in fact.
My lord, and the naval commandant, my lord, mentioned in the order, your lordship, in the last handwritten, Mr. Mahapatra reported at this college on 30th March 2020 and departure from this college to his unit on 4th April 2022. The occurrence place is, my lord, different. Because, my lord, I lodged a complaint against the opposite party number 2 and
when the occurrence has taken place?
Your lordship, may kindly have a glance to page number 9, my lord. That is the FIR. 3 April 2022. 3 April 2022, my lord.
And it is in the annex up to 4/4/20. Next thing.
So 30th March to 4/4 March 4/4/22, he was not there. That's what he said. In between.
But the occurrence, my lord, second place 3/4/22.
Right. And 3/4.
He is given 4/4, my lord.
He was not there on that.
On the next day.
These are,
On the next day, my lord. Yeah, 4/4/22.
no, 4/4, na?
My lord.
Previous date has happened.
Exactly.
3/4. So he joined in 4/4. So on that day he was not there. That's what he said.
My lord, he's saying that, my lord. But in fact,
These are the defense documents.
free of argument.
Defense document.
That is by.
But see, what I'll do is,
Good case for
I can direct the trial court to expedite the trial.
My lord, this is,
3 months.
your lordship, I will take 30 seconds, my lord. I am working with the naval unit, my lord. If I will appear before the court, then they will initiate a court measure by the naval unit. I will face the departmental proceeding, your lordship. In this case, my lord, what happened? The police investigated the matter without considering my document. My humbly prayer before this honorable court, your lordship may kindly direct the police officer to consider my documents. That is
After charge sheet is filed, why should I do it?
My lord, without they mentioned, only I will take, my lord, page number 36 may kindly have a glance.
Charge has been framed.
I have not, but first time, my lord. Second time, yesterday, notice.
Charge has been framed.
Charge not framed, lordship. It is 294/506 offense, your lordship. My lord, 36 page number kindly have a glance. Page number 36, the brief fact of the charge sheet. Here the police mentioned, my lord, during course of investigation, I have visited the spot, examined the complainant as well as the relevant witnesses and recorded the statement. After discussion with the, I issued 41 a notice and allow the accused person go there. They never issued 41.
Go to their house without arrest.
If they will issue 41, then I will disclose my fate that I am not there. I will.
The entire case is required, my lord.
Call for a case diary. This is a case where some indulgence has to be made.
Your lordship,
despite notice, opposite party number 2 has not appeared. In the interest of justice, one more opportunity is granted to opposite party number 2. In the meantime, Mr. Ragada submits that he would be calling for the case diary, obtain the case diary. Release the matter after 2 weeks.
Interim order passed earlier on 19 January.
Interim order to continue.
Grateful, your lordship.
Just check it up.
This I will take instruction specific in that annexer, my lord.
That annexer, because they are defense documents.
Whether that is genuine or
See, the problem is, had it been the ordinary thing, I would have said okay. But there will be a court martial. Immediately it will follow.
If the annexer will find genuine,
then he has to be given that relief. Otherwise, he will lose the job and again he will acquit it also. That's the problem. Yes.
Grateful, your lordship.
May I please, my lord?
Yes.
This is an application for quashing of the cognizance order, my lord. Yes. It's a private complaint. My lord, order dated 7/1 at page 36, my lord, 1/7/2019.
Service. Private complaint service completed.
My lord, so they have appeared perhaps.
Sangram Kumar Das, my lord, advocate.
Okay.
Somebody has appeared.
Yes.
My lord.
Private case,
my lord.
Complaint under section?
Complaint under cognizance has been taken on section 341, 294, 323, 379, 406, 420, 506 by 34, reduced section 3 of the SC Act, my lord.
Yes.
My lord. My lord, background of this case is, my lord, the complainant who was working as the security supervisor, my lord, under Mrs. Krishna Charan Swami Security Agency and attached to IOCL Paradip. My lord, subsequently, the tender was taken over by one Mrs. Pratap Ghosh Security Agency. When Pratap Ghosh Security took the charge, not only the agency, but also the manpower also taken over. Now, this complainant who was working as supervisor, he has to act under the present petitioner number 1, who was then appointed as the administrative manager, operational manager. My lord, that was that department because he was
personal manager of what?
Of that Pratap Ghosh Security Agency.
Okay.
Now, my lord, for that reason, he became junior because though he was senior, he became junior. So there was a hostility.
No, the reasons I am not interested in.
Lord,
you tell me what are the.
My lord, that is the reason. Now,
maybe whatever.
My lord, what happens? Allegation is that in the year 2018, my lord may have a glance to the death chart mine.
Now, why should I quash it? All these things are your defense.
My lord. My lord.
For quashing, you have to tell me the startling facts. Not that you, this had happened, that happened.
My
You
lord,
prove that.
sole allegation of the complainant is that
Hmm.
I had borrowed a cash of rupees 2,60,000 from the accused.
Okay.
That too for purchasing a car.
Hmm.
Now, as I found, as I have also enclosed the documents, by that time the accused has already purchased the car on loan
Oh,
from
again,
ICICI
that-
Bank. My lord may have a glance
That is
to
not the
Annexure 6, my lord. Annexure 6, I obtained the loan from ICICI Bank. In the year 2017, I purchased the car. My lord may have a glance to the evidence statement, that is 202 cent statement that has been
you
recorded.
show me the complaint and show me the 202 inquiry.
My lord,
If any case is made out, you have to face it.
My lord. My lord may have a glance to Annexure 4, my lord, the statement, initial statement of Srikanta Sethi, the complainant in this case.
Page-
Annexure 4 at page 30.
Yes.
My lord got it? First 3 lines. In course of staying with me, accused Aniruddha had taken rupees 2,60,000 in 2 installments for repaying his car loan. This is the allegation that I had borrowed a sum of rupees 2,60,000, that too in the month of April 2018, my lord. My lord, fact remains, I have enclosed the entire documents which I have obtained from ICICI Bank, my lord, where I have availed the loan from ICICI Bank in the year 2017 and at Annexure 6, my lord, at page 37. And the total loan amount was liquidated on 1/4/2021 at page 40. So there was no question on my part to avail any loan for purchase of any car, my lord. My lord, what happened? In a false case, I was detained in custody by the in Bhubaneswar court. In a Bhubaneswar
Come
court.
to page,
By that time,
come to page 29
mine.
and read the evidence. All the story, and why are you telling me all the story? See the evidence.
My lord.
Is it not sufficient for proceeding against you?
My lord, by the time the
These are all your defense, sir. You read it.
Yes, I have gone through, my lord. What happened
You
by
are
the
not-
time?
You are conveniently not going through.
No, my
Read
lord.
it.
I am not suppressing. I am not suppressing
Read
it.
it.
That I have already enclosed, my lord.
Everybody know that you have a case or not.
No, my lord. What happened?
Not
My
suppressing,
respective submission
very,
before my
very
lord is-
specific allegation with detailed narration.
My lord, the detail, the allegation, the date of occurrence, my lord, on the very date of occurrence, I was undergoing treatment as an indoor patient in a hospital. That I have also enclosed, my
So
lord.
then again, the indoor patient, outdoor patient, all these are alibi. There, the earlier case, I was intending because there is a defense document.
That I do understand, my lord. Unnecessarily, the allegation, the manner the allegation has been made, the transaction dwara Paradip. I belong to
You
Noapatna.
went at the see, you got down from the car, you went inside the house, came with a papers, and thereafter you asked her to sign and started scolding. See the language.
My lord, that
And
is the
thereafter
allegation
you
he has
threatened.
made. That is a
Yeah,
private
threatened.
complaint, my lord. That can be added, my lord.
What can be
My
done?
lord, what is the role of the
What-
petitioner number one, his
What
wife?
is the test for me?
My lord, what
Any
is the,
case prima facie is made out from the complaint and the statement. It is made out.
my lord,
It
what,
is made out.
as far as petitioner number one, there is absolutely no allegation, my lord. The wife of the accused to number one, my lord may have a glance. Petitioner number one,
To argue all this point at the
my lord, at the framing of charge,
petitioner has
Framing.
challenged the order dated
1/7/2019.
1/7/2019, whereby the court below had taken cognizance of offence punishable under section so and so 1/7/19 na page Suchi annexure 5 so and so. After arguing for at some length, counsel for the petitioner seeks to withdraw the petition to raise all these points at the before the court below at the stage of framing of charges. Liberty is granted and the petition is disposed of. Yes.
My lord.
85. May I please? My lord, I am challenging the order in cognizance the offence under section 498A along with the other offence. But what happened, my lord? The petitioner and
Who are you? You are
I am the husband, my lord. All the in-laws, my lord, the police submitted the charge sheet against the husband, in-laws are, my lord. Here, my lord, what happened?
I'll simply issue notice.
My
Issue note, issue note. Let her come.
My lord.
We'll try to settle it.
Because there is, my lord,
Time for
law,
settlement.
there is law of affairs between the two.
Wait, let her come. We'll
My
see.
It's
Yes. Yes, sir.
My lord, initially, the case was registered under section 147, 148, 302.
Charge sheet filed under which provision?
Yes, ma'am. Charge sheet, my lord, under annexure 2. Annexure 2, my lord, at page 26. 147, 148.
This is charge sheet. I don't think this is charge sheet.
Yes, ma'am, final form.
Huh?
Final form, ma'am, yes. 153A, 353, 120B, 149. But the case is that the petitioner was not there. And another relevant fact is that 2 FIRs has been registered by the police. One is Ottawa PS case number 37 and Ottawa PS case number 38, madam, wherein the present petitioner has been acquitted from the previous FIR, PS case 37, madam, by virtue of judgment dated 20.
Eight 23 charge has already been framed.
After 3 years of the FIR, madam. The charge sheet was submitted after 3 years.
So, Mr. Ponda, against him, what are the allegations?
My humble submission is that on 24/9, I have taken that ground at page 12 of my petition. On 12, by judgment dated 24/9/2021, the judgment passed by the Learned Assistant Session Judge R. Udayagiri, arising out of Ottawa PS case number 37 of 99, the present petitioner has been acquitted. And basing upon my same evidence, the Ottawa PS case 38 has been instituted. At night, PS case 37 and at the daytime 10:30, Ottawa PS case 38 has been registered. Wherein the petitioner was not present on the spot, neither he was involved in that incident. Another thing is that I have also taken that ground. The learned court below rejected my discharge on the ground that section 301 and 300 subclause 1 and subclause 5 of CRPC will not be attracted. May I place that provision?
Where is the charge is framed?
Charge frame, my lord, on 28/8/2023.
23.
Page 85, page 85.
Evidence must be going on.
They have taken remand, my lord, on in this case on 7/4/2017, my lord. My lord, kindly consider the aspect. The petitioner first was arrested on 18/7/2014 in connection with Bodbazar PS case number 127 of 2014. And after, my lord, incident is the year of 99. After 18 years, they 99. After 20 years, they have framed the charge. And they have remanded in the year, my lord, 2017. One after another, my lord, they are instituting the cases, and trial has been delayed. Admittedly, my lord, trial they are not.
How many accused persons are there in this case?
My lord?
How many accused persons?
How many?
How many accused persons are there?
My lord, they have initially, my lord, added 300 persons.
Now, charge sheet.
Yes, charge sheet, my lord, 32 perhaps.
Perhaps you read it and come.
My lord?
Read it properly and come. Adjourn it.
88,
a
87.
charge sheet.
In such a serious matter, you have to be very much ready. Abstractly you are saying one sentence, thereafter leave that
No,
sentence, go somewhere else.
I am reading.
I'm
showing
doing
it.
your job.
Annexure 2, my lord.
No, not like that. You structure your argument and tell me. And these are they are the moist. It's not this you so casually you are arguing. Read it properly.
Arms Act section.
I know, I have seen it. By the time you are telling, I was reading it. That's all.
I'm sure the
What
sanction,
you are
but
saying,
but with regard
some
to
sentence somewhere you picking up. You have to structure your argument. These are serious matters.
what
No,
my
you can't argue so casually like this. Yes.
what my learned senior is arguing.
Yes, next.
87.
Prepare and come.
May I please, Your Lordship?
Prepare a note what exactly has happened. Your documents are not legible. Nobody can make out anything out of it.
20 ବର୍ଷ document ଆମେ
You have to
certified copy ରେ
prepare
ସେମିତି
a
ଦଉଛନ୍ତି.
written note and give me.
Yes, ma'am.
What is your case?
A short date would fix.
Yes. Next.
87.
May I please,
87.
Your Lordship? 87, may I please, Your Lordship?
Yes.
But Your Lordship may kindly see the order dated 27th February 2024.
27th February.
Yes.
Yes.
While issuing notice to the opposite party number 2 wife, Your Lordship may is that operating portion at para 4. The learned counsel for the petitioner submits that he would be moving appropriate application seeking adjournment
What do you want?
before the
Yes.
but despite issuance of notice, wife has not appeared as yet before this honorable court.
What is the service of?
Now, the adjournment petition, when the adjournment petition is being filed before the learned trial court, the order of NBW has been issued. That is why I have filed the interim application. The present IA has been filed against the NBW order dated 12/8/2024.
Which IA number?
IA number 2347.
Yes. What do you want in this IA?
No, that this order of NBW may be stayed.
Only this IA is registered today. The main matter is
Yes,
disposal.
yes. This IA has
For the reasons stated in the IA number so and so. Where is that NBW order?
NBW order in IA at page 8.
Yes.
8 and the operating portion is 9.
Order dated 12/8/2024.
Yes, ma'am.
12/8/2024.
Yes, ma'am.
By which the court of JMFC Jajpur Road in ICC case number 362 of 2023 issued the NBW NBW which is state subject to the petitioner appearing before the court below on or before 30th of September 2024 and seek remedy under law. With this observation, the petition application is disposed of. You appear. Until then, I have stayed the NBW subject to the condition that you appear on or before 30th of September before the court below.
Main case disposed of.
Disposed of.
Main case.
Main case is already disposed of. Yes.
No, main case is pending. Main case is pending. No, main case is pending. Notice was issued to the wife.
Okay,
Your Lordship.
Lease the main case after 30th.
Lord, appearance of and all the accused persons, Lord, it will. No, she has included the entire villagers also, the entire neighbors also.
Next.
Maybe let's see. See, Belgium matter previously, my application was allowed, but see, I filed for IA for extension of time.
For the reasons stated in the application, the extension of time sought by the petitioner to surrender appear before the court below is allowed, and petitioner is directed to appear before the court below on or before 30th September 2024 and avail remedy under law. And the rest of the order dated 16/5/2024 will remain same, yes.
89.
Allowed, huh? 89.
There are two appeals and two miscases are pending. In the first case, my lord, at fact C one.
Those miscases are of the year 2007
What is that?
for suspension of sentence.
We're
That
not
can be
pressing it.
finally heard, my lords. Let it come in the
Suspension of
weekly.
sentence?
Yes, my lords.
Not
No.
permission. And
We are not
suspend the
pressing
sentence.
it, my lord. We are not pressing it.
They are not pressing, my
Okay.
lords. Let it come for hearing in the
What,
weekly.
what was the sentence?
1 year, my lord. 1 year.
Why sentence was not suspended? Missed.
Already.
Let it be tagged in the weekly.
Dead and they are being substituted by the wives. So, my lord.
Right. Let it be tagged in the weekly, my lords.
Huh?
It may be tagged in the weekly for final hearing.
90.
90 requesting for a passover on behalf of Mr. Sangram Das.
Modification of the order.
Which model?
1997 lawsuit directed to release the 3,50,000 subject to convert of the bank guarantee and the
Bank.
indemnity bond.
Huh.
So I have tried my level best. I have not, I bank guarantee to release that amount for which I have said that indemnity bond can be accepted.
No, my lords. Bank guarantee.
That was the condition.
Yes, my lord. It was a consent order, my lord.
I'm not inclined to.
Condition of
Yes.
I'm not inclined to
It was-
modify the order.
Visualize.
Because I visualize everything. That was the condition I have.
It
allowed.
was a consent
And
order.
today
my
You
lords.
took the order and now
Yes.
you are asking for it.
My lords.
I'm not inclined to entertain the application seeking variation of order dated 9/7/2024 for the reasons stated in the application. Hence, the application is dismissed. Next.
Grateful, my lords.
91.
In this case, the
In
petition.
91 and 92, my lord, both the cases have been challenged,
I am the
order of
petitioner.
taking cognizance. This matter was earlier being conducted by Mr. Pani, one of my associates. After his termination, I have been entrusted with the same. The counter which has been filed on our behalf is not available with me.
Counter
So is
in a
your lordship-
criminal case,
Reason
there is
the-
no provision for counter.
Now, in counter, we have relied on certain decisions.
Let me
So
ask,
I may be
let,
permitted. If
there is certain
Actually,
development, let
He
me.
has said counter, but he is not prepared. That's
No, no,
common part of it.
I have no objection taking, if it takes time, but I have a difficulty.
Yes.
What difficulty? Difficulty that is in this case, the petitioner is a executive engineer. He was not in the affair. No, he was not named in the affair. He's a chief engineer, sorry, sir. He's a chief engineer. He was not named in the affair. Now, while taking charge sheet, submitting charges, taking provision to some of the taking resort to some of the provisions of OPW Act, he was added as an accused. But we came up before this honorable court, both on the points of facts and law. Facts is that the opposite certain provisions of OPW Act is not because
That is again on merit you are talking about.
no, what I'm coming. Then this honorable court granted stay. That stay continued till it was listed before the Honorable Chief Justice on 27/4/2023. Your lordship may see the
Yeah.
order sheet. List this matter before the roster bench on 31/7/23. The interim order shall continue. So there was no listing after that. While the petitioner was in US, he received information that the case is being taken up by the Vigilance Court, and the Vigilance Court is continuing with the case when the stay order is there. That is the whole predicament I have to
Show
mention.
me the proceeding.
Millers,
Show me the proceeding of Vigilance Court.
I'll get it next Monday, Tuesday.
You get it. You can't make allegation. If there is a stay order by High Court, how can the trial court take
Yes,
it? The client may say whatever.
I'll get it, your lordship. He is taking time. Lordship will fix it to next week.
I mean, anytime what happens is the court keeps on adjourning the matter, awaiting the outcome of the proceeding.
When
they expect the accused person to appear.
when the stay has been granted by the Honorable High Court. No, Asian resurfacing.
He doesn't say that.
Asian resurfacing the court that has been.
You show me the proceeding of the Vigilance Court. That matter is still going on despite the stay. Then
Yes.
can do something.
Your lordship may, as per his
Let him prepare and
Your lordship may extend the stay. That's only my mind.
after 2 weeks, interim order to continue.
Obliged, my lords.
Yes.
My lords.
Next one is same.
Please.
Next one is
May I
same.
take the copy?
Yes, yes, of
Xerox
course.
copy of our counter.
Yes,
Our
you can take it.
Next one is same. Both the matters are
Both
same.
the matters.
Your lordship fixed date, only prayer.
Date.
1991.
Your lordship fixed date.
Yes, yes, 93.
1991.
91 and 92, same matter.
Next 93.
Your lordship fixed date.
This will be fixed, sir. In all matter, I am fixing this.
Obliged, my interim order to continue in second
Interim order
matter.
to continue, both the matter.
Obliged, my
I will also in the meantime take instruction whether the trial has proceeded or not.
Just tell me.
I'll take.
93.
May I please?
And concentrate on merits also.
Yes.
Instead of diverting our main thing here and there, let us here and finish it up.
We have mentioned everything else in our counter. By relying on
Counter is not a criminal case. A counter proceeding.
They are trying to rely upon some document filed in the counter. And
They can say, they can produce the CT, they can produce the charge sheet. The counter is
Yes, yes.
taking the new facts.
It's all right. Next,
Obliged, my lords.
we have 134 minutes.
For passing of the FIR, which was initially registered under section 306 of the IPC, my lord.
306
of the
306, my lord.
306. my lord.
Petitioner is FIR named accused, my lord.
FIR named in the FIR.
And
my lord.
the petitioner has been gave mental torture to the deceased
Lord, may I submit?
regarding making a telephonic repeatedly that your wife has illicit relationship with many other peoples. By this process and due to he has lost his mental condition and committed suicide.
Yes. My lord, here, my lord, allegation is that, my lord, the petitioner, who is a lady, and the informant, who is also a lady, my lord, she has alleged that the petitioner used to call the deceased and state about the illicit relationship of the wife, who is the informant now, my lord. To that effect, my lord, your lordship may kindly turn to page 18, my lord. I have at annexure 2 series, the inquest report, wherein the brother-in-law.
What is the stage?
What is this
Charge
time, my
sheet
lord?
has
It is
not yet
coming
been
first time, my lord. You
Huh?
can
No, not first time. Charge sheet has not yet been submitted.
My lord, your lordship.
Opposite
Lordship,
party
I'm for,
number
I'm
two,
for,
the
I'm
informant.
for informant, my lord.
Investigation is still going on.
Yes,
You tell me, investigation is still going on.
So go on, I will take the instruction.
My lord, by virtue of the order of the court, they are not taking any action, my lord. Even
Which
the
court? Which court?
your lordship may kindly see the order.
This court have not stayed the.
In this case, my lord. In this case, my lord, or interim order has been given, my lord. That is why he has not taking any step, my lord.
your lordship may kindly
But here-
refer to. Your lordship may kindly
I
refer
have
to
filed
order number
objection,
4,
my
my
lord.
lord. Please. Order number 4, 28/10/2022, wherein it has
What
been
is CT
clearly
case?
stated, my lord.
What is CT case shown to? Investigation is still going on.
Still going
My
on.
lord, going on means it has remained stayed by virtue of the order of this honorable.
Never.
Where is the stay of?
Your lordship may kindly have a glance.
One after another. Let him say what.
28/10/2022 order, my lord, of this honorable court.
22/8/2022.
28/10/2022. Order number 4. Lord, in this case. Order number 4.
20, yes.
My lord, paragraph number 2, last line, my lord, may I read, my lord? This court clarifies that though the further proceeding which is pending before the learned court below in city case number so and so of 2021 shall remain stayed, but there shall not be any bar or restriction for the local police to continue with the investigation.
Where is this?
But on this basis, also they are not taking an action.
What are you?
Lord, this has-
My lord, I have to take the instruction, my lord, because this file has reconstructed today.
Right on.
It was
Further, my
And
lord,
by
your lordship may
The petitioner is seeking quashing of the FIR, number so and so, so and so. Let it, counsel for the complaint submits that in view of the, by misinterpreting the interim direction of this court, the investigating agency is not proceeding with the matter and filing the charge sheet. My attention was drawn to the order dated 28/10/2022. The coordinate bench of this court has amply cleared regarding the scope of the interim order passed while order dated while its earlier order dated 22/8/2022 and made it clear that the interim order passed on 22/8/2022 shall not be construed as construed to have been construed construed to have been passed for saying the investigation. Mr. Rahul, the counsel for the state submits that the order, the earlier order of this court is amply clear. Since there is no stay operating for the purpose of investigation, the police might have proceeded in the matter, but he doesn't have the instruction, and he seeks 1 week time for seeking instruction regarding the stage of
My lord, free
investigation.
copy, my lord.
Stage of investigation.
My lord, the interim order of no course of action may kindly be taken.
First, my lord, your lordship.
That's the whole difficulty. First, you took one interim order. Secondly, it is modified. Thirdly, I will pass some
Your
order.
lordship, I'm just clarifying, my lord. Well, initially.
There is interim order, there is interim order.
And your lordship.
Yes, my lord. That may
Anticipatory
be
bail
granted.
application filed, that was rejected. Again filed anticipatory bail application, that was rejected. Thereafter filed.
I will not say anything on interim.
Yes, my lord.
Whatever order is there, there.
But
Yes.
that may be continued.
That's
No.
continue.
Great.
Item 94, my lord, I am challenging the order taking cognizance under section 92 of the Factories Act. My lord, I seek thought adjournment, my lord, and take instruction from the, I got instruction.
Nay, what is your case? This
My lord,
offense is not made out.
offense is not made out. and the
What is
person
made out then?
Who, my lord, not made out, the rash and negligence is made out, my lord, on the very same, my lord, under Annex 3, FIR registered. Police investigated the matter and submitted the charge.
Yes, yes.
And accordingly,
On-
the
on-
cognizance taken.
He is seeking adjournment. Adjournment.
Sought adjournment, my lord.
Yes.
If I, interim order is there, my lord. Kindly.
Interim order is there.
My lord, interim order is there.
Why are you asking?
Sought adjournment, only instruction. Your lordship.
What instruction?
Huh?
What instruction?
In the meantime, I got instruction, petitioner number 1 retired from the service. Whereabouts, my lord, is correct.
894, na?
94.
These are not relevant in this thing.
Because of my lord, relevant, my lord, because they are, at the time of my lord occurrence, my lord, they are, my lord, the petitioner number 1 employed, now, see, my lord, he,
See, 17/10/2022, you have taken the stay.
my lord.
Till today, you are seeking instruction only because stay is there.
My lord, not listed, my lord, there are not, today the first time listed, my lord, there are.
Once you take the stay and then
And
thereafter you
today,
keep on asking for.
Only, my lord, only 5 days, my lord.
Let us see what is the case.
Yes, your lordship.
I don't think for cognizance order, I need to stay. I'll vacate it.
My lord, your lordship kindly say Annex 1, my lord. Annex 1, my lord, submitted by Assistant Director, Factories and Boiler.
Who are you?
My lord,
Occupier.
we are the, my lord, the petition number 1 is the CEO and the 2, my lord, working under the ex-director.
Huh?
The petitioner number 1 is the ex-director and CEO.
Then you are occupier.
My lord.
Under the act.
Under the act. Your lordship kindly see what happened here, my lord.
Now, what are the allegations?
My lord, the allegation, your lordship kindly see. The allegation made by the assistant boiler, what the fact is, my lord, the petitioner company, my lord, where the present petitioners are employed registered under the factory. My lord, one summer builder, my lord, who is, my lord, on as per he taken the contract, my lord, to shift the ash, my lord, from a pond, my lord, to different. He engaged the truck, and one excavator. While, my lord, the truck are going, my lord, and lifting, one of the driver, my lord, got down from his seat, my lord, and the first truck, my lord, dashed the back and he died. Thereafter, the FIR register, police investigated the matter and submitted the charge sheet under section, that is the charge sheet I have given under Annex 4, my lord. Now, my lord, the assistant boiler, my lord, given the allegation that since the SOP has not read to the person concerned, the worker, therefore the present petitioners are liable under section 7 C of the Act. You will also kindly see the Act, Factory Act. 7A. 7A of the Factory Act, you will also kindly see.
My lord, your lordship may kindly have a glance to the running page number 14, my lord.
In fact, you will also kindly see the Act, whether the Act. So in this is the.
In the instant case, the management has violated section 7A 2C of
That
the
Act I am reading.
Factories
That
Act
Act.
1948.
7A. You will also kindly see 7A of the Act, my lord, Factories Act 1940. every occupier shall ensure so far as is reasonable, practicable, the health, safety, and welfare of all workers. While they are,
Under the sweep of this, you being the occupier, you are.
but you also can see, my lord, that the all worker, while they, my lord, he is not a worker. My lord, the deceased is not a worker under the.
That has to be proved.
My lord, here, my lord, it is already proved, my lord, as per the definition, my lord. Thereafter, your lordship kindly see their work in the factory without prejudice to the generality of the provision subsection, the matter which such duty extends shall include the provision and maintenance of rent. Thereafter, see, my lord, the provision of such information, instruction, training, and supervision as are necessary to ensure the health and safety of all workers at work. Your lordship then kindly see the definition part. The worker, my lord, they are defined.
Yes.
Worker means that is I. Worker means a person employed directly or by or through any agency, including contractor, with or without the knowledge of the principal employer, whether for remuneration or not, in any manufacturing process or in cleaning of any part of machinery premises used for a manufacturing process. Here, my lord, he has not worked under the manufacturing process, though he has worked under a contractor. He worked under the thermal builder, my lord, but not included in the manufacturing process, my lord. Thereafter, your lordship kindly see the next, my lord, the complaint petition.
Transportation of the product outcome of the factory is also part of the factory job.
My lord, I have got
And every contractor who are working for transportation of the product is also included under 7A. That's the judgment.
No, my lord, exact to my decision, my case, my lord, I have got a decision of the Honorable High Court of Bombay at Aurangabad bench. Here, my lord, 7C, my lord, dealing with that, my lord, the Honorable High Court of my lord.
Which
Bombay,
factory was that?
My lord.
What was the factory?
My lord, here that is the Melon Laboratory Limited. There, my lord, the worker is not working under the manufacturing. That is dealing with that, my lord. The Honorable High Court, my lord, was there.
You give a written submission. Judgment.
That's why, my lord.
Judgment reserve. Judgment reserve. I've heard it.
No, my lord, I short you.
No. You give written.
On Wednesday, your lordship, I will that day.
Give written submission. I'll deal with everything. Don't
My
worry.
lord, your lordship.
I will write. I'll deal with your judgments also. Don't worry. You give a written submission.
My lord, I will give on
Judgment reserve. 1 week time granted to give written submission.
My lord.
If further hearing is required, you just tell me.
Yes,
no problem.
I will.
Yes.
95.
And all the citation which you are relying upon, please highlight those citation.
Yes.
And the provision also you reproduce in the written submission. Thank you. Yes.
95.
On behalf of Mr. Boral, my lord. And opposite party number 2 has submitted the counter. The copy may be served on us.
Copy?
Copy may be served.
You are appearing for whom?
For the petitioner, my lord.
OP2.
You have to give the copy. Let counsel for the petitioner submits that he has not received the copy of the response filed by the opposite party number 2. The opposite party number 2 may supply the copy of the same. Please the matter. Okay, to 4 weeks. Yes, next.
My lord, interim order to be continued.
Interim order.
Home Minister.
96.
Yes, sir.
That matter for 2,000 rupees, cognizance has been taken. Dispute is purely of civil nature.
My lord,
I received the.
It's not question of 2,000, your lordships. It is the question whether offence has been prima facie. There are materials to actually take cognizance by the learned magistrate. Actually, magistrate has rightly taken cognizance or not. My lord, if more than 50,000.
He also knows it. Therefore, he said 2,000. He knows it.
Suppose one person has committed theft of rupees more than 50. So then it will be said that the matter of 50 rupees should be written.
Can't it be settled?
It was referred to mediation. Before the mediation center, he also did not agree. That is the report of the mediator.
Small matter, why?
Your lordship may kindly see the
Ego issue.
No, it is not ego. But the properties of the predecessors of the complainant and also the client of my friend. What has happened that by manufacturing that Dattapatra and sell deed, but that is mutated in his name. The civil suit was preferred. The decree was passed. Whenever my lord, decree was passed declaring that gift deed and the sale deed void, utilizing the same gift deed and sale deed, he has mutated his name. By producing those documents, my lord, he has got the government money.
Mutation will be set aside.
My lord?
Mutation will be set aside.
No, but money which has been taken from the government, by utilizing the same paper, my lord, by manufactured one which he is not entitled to.
Compensation.
Yes.
Under section 31.
No, filing compensation.
Filing
Ex
compensation.
gratia. Page 19, your lordship may kindly see. Page 19 of the brief.
But what to do if he is not agreeing? If I go strictly on this basis of offence is committed,
My lord, my humble
what can I do? That's the reason I send it to mediation if anything can work out. He doesn't agree, then what can I do?
my humble submission, I have a case by virtue of section 95 of the CPC. Section 95 of the CPC is IPC, your lordship may kindly see. IPC.
IPC. 95.
These are trivial matters for which nobody should go. Nothing is an offense if it is
Yes, 95.
95 IPC.
Yes.
Act causing slight harm. Nothing is an offense by reason that it causes or that it is intended to cause or that it is known to be likely to cause any harm if that harm is so slight that no person of ordinary sense and temper would complain of such
That is
harm.
an offense. That will be applicable.
Because, my bona fides, your lordship may kindly see from page
In
19.
our PC Act, those who are taking 200, 300 bribe, everybody will go out.
Special act.
2000, so employ 95.
That is an offense. That will be considered on the facts and
If he
circumstances
is
of it.
not aggrieved, if a complainant is aggrieved, then so it may be it may be slight for you, may not be slight for him.
No, it says if ordinarily
For every accused it is slight, but the complainant is not slight.
page 19, your lordship may kindly see. Once an FIR was filed and it was a final report was submitted, the finding of the police, I offered the money to her because the ROR was standing in my name. None other than me would have received the amount because this is ex gratia payment.
What is the loss cost to you?
Loss is, my lord, whenever my lord offense is committed, my lord, it is
No,
committed
what is the
against the
loss
state.
cost to you? Tell me, sir.
Lost is, my lord, that money which my lord and friend is now saying, that money I am entitled.
Therefore, he says 95.
No, 95 is an offense.
95 is
95,
slight harm.
95 IPC is, my lord, completely one offense.
No, no, no.
On the facts and circumstances that will be taken into
Offense.
consideration.
An
And 95 will not be applicable here.
An offense which is ignorable can be ignored. That's what he says.
That is on CRPC it can be said, but on IPC it can be said that it can be ignored.
Definition clause.
But 95 IPC.
What is the loss cost to you?
Loss, your lordship, that is,
2,000 rupees.
might be 2,000
The
rupees.
entire system will be for you. I have sent it to
But fact
mediation work.
You lordship may kindly visualize one thing. You lordship may kindly see, visualize one
Technically,
thing.
you may be correct. You tell me what is the harm.
No, it is.
How much compensation you want? You tell me, I'll tell him.
But in the
Finish it up.
police, what
Try
has
to be practical. Try to be practical.
what is written?
See, there was a decree. You own the case. The property is declared to be yours.
But
And you
and about 1/7.
My
1/7.
1/7.
And he has misused some document and mutated and got some.
No, ROR was standing in my name. He should have corrected it by execution.
And you took it and you did not.
Because it was in my name.
By utilizing that ROR.
I think these kind of cases should be quashed in the interest of the system. These are clogging unnecessary.
And
it is a burden on judiciary only because of an ego of 2,000 rupees. The entire system has to work for you.
I gave this
Not on merit. Merit you have difficulty. I am on the other part of it. The fact remains, it is a loss to you by 2,000 rupees. You people are relative. You got a degree. There is no prejudice to you. I have sent it to mediation. You say, no, I'll send you to jail only. What is it? Think over. Think over, you ask your client, I am putting it next week.
I have
Otherwise, I'll call.
I have asked my client, your lordship. Anyway, your lordship may keep it to some other day. I will take.
You
further
can't
instruction.
satisfy your ego at the cost of judicial system of this country.
Yeah, absolutely, your lordship is absolutely correct. I
Very
don't dispute it.
unfair on your part.
What fact?
Tell your client, otherwise I'll, in any case, I'll quash it. But tell your client, that is the reason I send it to mediation. Unnecessary.
Well, two previous orders of two different benches.
Anyway,
I have come with the draft.
Tuesday, Wednesday.
Wednesday, my lord, I will not be there.
Wednesday?
1 week after your lordship may say.
Then coming Monday. Monday, huh? Monday. You please persuade your client.
17th.
And otherwise I'll pass it on merit.
Your lordship.
Yes.
So what will happen, your lordship may visualize.
The interim order.
My client is not actually agreeing. If your lordship will quash it, my lord, I will not be visualizing in any manner.
Why should I
But
waste
fact
time?
remains-
There are many people waiting.
Right.
Only to satisfy the court is engaged.
Definitely.
High Court is engaged and trial court will be engaged. Only for 2,000 rupees, your ego. And this kind of cases should be quashed with heavy penalty on both of you. I'll tell you, I'll quash and I'll write a judgment, impose cost on you because you have been using the system for you to settle your ego. Definitely, I'll pass 50,000 rupees cost to both of you and quash it. I take it from me. I'll do it.
It will be enriched.
Why unnecessary all this?
Interim order to
Interim order to country. Yes.
97. This matter has been settled.
Yes.
Already settled. Joint affidavit has been filed.
Where are they?
Hello?
Have they come?
So far, I have no
No, Amara
regarding the joint affidavit. Lord. I have no knowledge about the joint affidavit. Let's serve a copy of joint affidavit. I will appeal instruction.
I'll put it next week.
issue notice ଟା ହେଇଯାଉଛି appear କରିଦେବେ ଦି
He
ଜଣ
is
ଯାକ.
already appearing.
FIR under 376 million. 376.
I have no objection, no objection ଦେଇ ଦେଇଛନ୍ତି ଓକିଲାତ ନାମରେ.
No, he is appearing, he says.
Yeah, appearing.
He is appearing.
ନାଇଁ ଓକିଲାତ ନାମା ଦେଖନ୍ତୁ kindly see the ଓକିଲାତ ଭି ନାମା.
If he says that I am appearing, I have instruction, I can't.
consent ଦେଇ ଦେଇଛନ୍ତି ନା. ମୁଁ ସେଇ ଯୋଉ କହୁଛି please kindly see the ଭି ନାମା.
I will not go into all this thing. The client says that he is saying I am appearing, I will have to go by his statement.
ନୋଟିସ କରିଦିଅନ୍ତୁ ସେ ଆସିବେ ଆମର ଇନଫର୍ମାଟିଭ କୁ ନୋଟିସ କାଇଣ୍ଡ
Some learned lawyer comes and says that I am appearing for someone. Why should I doubt? Why should I check whether your Vokalatnama is given or not? All these things doesn't look nice. He is appearing for someone. Give a copy. The joint affidavit. I will put it next week and see.
ନେକ୍ସଟ ଡେଟ୍ ରେ ତାଙ୍କୁ ଡାକିଦବା ନୋଟିସ ନୋଟିସ
No, no. ଆପଣ settle କରିଛନ୍ତି ଆପଣ ଡାକି ଆଣିବେ ନା ମୁଁ କାହିଁକି
ଏଇଟା ହେଲେ ସୁବିଧା ହନ୍ତା
No, no, no.
ହଁ ଠିକ ଅଛି ମୁଁ ଡାକି ଆଣିବି
You have settled.
ହଁ ବୋଥ ପାର୍ଟି ଡାକିଦେବି
Yes.
ହଁ ମୁଁ କପି ଦେଇଦେବି
ହଁ ଡାକି ଆଣନ୍ତୁ next.
କାଇଣ୍ଡଲି ଡେଟ୍
ହଁ date.
ଡେଟ୍ ଟିକେ
98.
oblige
Issue notice the opposite person. Notice service. It is. Huh?
My lord, already other side appeared, my lord. My lord,
Appeared?
this is for passing up FIR, my lord.
But I am appearing from the virtual court Keonjhar. Let's say grant me one time, I'll file 1 week time. I'll file my counter. This matter is not mentionable, my lord.
Not.
But your lordship may call this matter.
Pursuant to the notice issued to opposite party number 1, Mr. Das is entering appearance.
Along with CRLMP 505, that
1 minute. 1 minute. He seeks 1 week time to file counter. He submits that a connected matter is also pending, being
matter disposed of, my lord. CRLMP 505 of 21
disposed of.
and CUNTR 34 of 23.
Tag.
Any date convenient to my friend. Any date convenient to my friend.
Yes, next 99.
My lord, next week,
99. He will give a date. Yes, 99.
99, my lord, I am permitted to file one IA for modification of the first title. It should be revision. It is not should not be shall.
What have you filed?
I have to file one IA for modification.
You want to
My lord.
nomenclature to be changed.
Nomenclature.
Same order for you.
Revision is maintenance.
They is directed to change the nomenclature, renumber and meet the appropriate code subject to.
That has to come again.
What?
I will pass over on that.
No, she is making an oral prayer.
No, the change.
I am accepting your oral prayer. Don't
Fine.
move application, wasting time on the oral prayer. What application? I have allowed on your oral prayer and do it.
Hmm.
Oral prayer. Or he will move application again, the matter will be
Again, matter.
made, all these things not required. Oral prayer is allowed to be renumbered and at least before appropriate point, subject to the approval of the honorable chief justice. Yes.
Okay.
Item 100.
May I please, Madam? Let's say in this case, yes, I am appearing the connected matter bills, connected CRLMC number 1003 of 2021 bills. 1003 of 21 bills.
Yes, sir.
This is a matter your lordship have earlier heard and treated to be parted, directing my friend to take instruction to refresh my lord's memory bills. Here, cognizance order taken under section 92 of the Factory Act, passed by London JMFC Jajpur, is under challenge bills. Because apart from other grounds, substantive two grounds are there, which bills your lordship will find out and out bills. The complaint petition, which is filed before the London magistrate, is barred by limitation under section 106 of the Factory Act. 106 mandates that complaint petition is to file within a period of 3 months from the date of occurrence or from the date of coming to the knowledge bills. This is one. I will elaborate bills. I will take my lord's attention. One. Second bills.
Mr. Rahul, are you ready?
But I think Mr. Ogada is appearing in this matter.
My lord.
He is to take it serious.
The factory people already appear, my lord.
Sorry?
Appear to Acha. Who is appearing? No, I am appearing for state. Took place.
And second bills, section 92, cognizance is taken on section 92. Your lordship have also rendered so many judgments, and my lordship must be coming across so many judgments where bills. Section 92 is directed against either the occupier or manager bills. But so far as the present petition is concerned, neither I am occupier nor a manager bills. I am a manufacturer who have supplied goods to the occupier bills. Because my factory is in the state of Madras bills. Because I belong to Chennai bills. Even the process also, as per section 202, actually postponed when the millers accused are outside the state of Odisha. There are two things, millers. Neither section 92, the very rudimentary, basic, fundamental tenets millers. Neither 92 attracts millers, which is invoked to take cognizance in this matter. And secondly, millers, so far as limitation is concerned, it is out and out above beyond 3 months. And on the very same matter, millers, and identical matter, two Jharkhand High Court judgments are there, and also Honorable Supreme Court also dealt in, but two Jharkhand High Court judgment directly on the issue, my lords. Here, if your lordship permit me, I will take my lord's attention 2-3 dates that will suffice for the purpose of my point of.
Show me the knowledge part.
Yes, exactly. Now, your lordship may kindly see the complaint petition, which starts from page 40. Complaint petition is filed by Assistant Director of Factories and Boilers. My lords, it is needless to say, Assistant Director of Factories and Boilers, as per the Government of India notification, comes under the definition of inspector, because he is the inspector who has to file complaint petition, and Assistant Director comes under admittedly comes under, because I have objected initially, they have produced one notification, I have yes, they come under, there is no denying
The
it.
knowledge part.
Exactly. Now, knowledge part. Your lordship may kindly see page 40, the date of occurrence is 25/6/2017. My lordship. Now, your lordship may kindly next page. The complaint petition is filed before the Court of London Magistrate on 4/10/2017. Now, knowledge part. Your lordship rightly points out so. Now, my lordship may kindly turn to the investigation report as page 45 minutes. Page 45.
Yes.
Column number 5, date and time of incident 25/6/2017 at about 12:40 p.m. Then location, a plantation area near finishing shop of hot strip mill. Then now your lordship, date and time of receipt of information and notice of accident. Telephonic information given by the management on 25/6/2017 and Form 18 received on 27/6/2017. This Form 18 is purported under Rule 90 of the Orissa Factory Rules, my lords. This is required to be given, my lords, where, my lords, and this is to be given to the inspector. And your lordship may kindly see, they acknowledge that Form 18 intimation is given to the inspector on 27/6/2017, my lords.
27.
And 27, column number 7, Form 18 received on 27/6/2017. The lordship got it. Serial
Form
number.
18 received
Yes,
2020.
exactly. Form number 18 is in the information in statutory format under Rule 97 of the Odisha Factory Rules.
Then
This
knowledge on 27.
knowledge is 20, exactly, 27/6/17. 3 months, your lordship can calculate, my lords.
October it is filed. 4/4 October. 4/4/2004, 10.
Exactly. So beyond what is the month? That has also been clarified. One of judgment saying that it will be 30 days. Means 30 into 30, 90 days. So if your lordship will be adding 90 days from the date of occurrence, my lords, 25/6/17.
4th October 2017.
Coming out and out beyond the limitation period, my lords.
How will you explain it?
That is true.
Under the limitation it goes.
That is, last occasion also, we are also asking me to take instruction to that respect, my lord. But I have a
Knowledge, date of incident or date of knowledge.
knowledge, my lord.
30 days, 90 days. Date of incident, forget it. Even if you take date of knowledge under your own admission and that column in the investigating report, you say that is 17/6.
My lord.
And complaint is filed on 4/10, much after 90 days.
My lord. For that reason, my lord, this matter urgent, my lord. Today.
Your lordship may kindly see judgment of Hon'Ble Jharkhand High Court, my lords, directly on the point, my lord.
What copy can
That is in the case
copy
of
may be given, my lord. Reply to that.
What
Hemant.
reply? I am reserving judgment, you give written submission.
My lord. And the judgment, my lord.
judgment, two judgments have given.
Like
Judgment will
10
be
days.
supplied to.
Not on merit, on limitation.
Limitation, page 48.
48.
Signature of the investigation officer, that is 4/10/17. Investigation has been completed on 4/10.
Maybe.
That is the
investigation
reported.
may complete whenever you want.
Yeah.
But from the day you come to the knowledge, you have to file it.
Correct.
You can do continue investigation.
My lords, on two
The
issues.
limitations will not stop because investigation is going on. It is a statutory limitation. There is no question of condemnation also.
That's my humble submission also, my lords, apart from limitation, because 92 goes to the very maintainability of the case, my lords, because they have taken cognizance under section 92. If your lordship will see section 92, my lords, that is always to be against the occupier, and occupier bears a definition, my lords.
That's
Your lordship knows, my lords. So, do I fall under either
you
of
are the
it?
manufacturer.
Exactly.
Somewhere
So,
else,
yes.
somewhere else.
So 9,000 at right. And what is occupier? In JK Industries Corporation, Honorable Supreme Court has said, if you permit me, I'll give a copy to my lords also.
Highlight those things and give me.
Yes. Paragraph 62. They are also said where paragraph 62, if your lordship will see.
Okay, I understood it. You give in writing.
So only on two issues, if your lordship addresses also that.
You write first issue.
My lords.
What are the judgment, which pages?
Right.
Second issue, what are the pages, which judgment?
Right.
This much you give, I'll
Within 3 days?
within a week.
Within a week, no, yes.
The
Investigation immaterial. Because
also within 90 days.
because the incident
Kindly see, 27.
incident and the knowledge or the knowledge. From there you have to count. Incident. I'm not bothered about incident. Knowledge.
Correct.
More important. All knowledge according to your own document it says 17/6.
27, 26/7.
27.
27?
17 or 27, whatever.
Just a minute. See.
Then it is beyond. 27/6, 27/7, 27/8.
27/6.
27/9 and 2/3 October.
They have given 2 days. One is telephonic information, that is 25/6.
And form is form.
Exactly, that is important. Like a statutory form.
That's it.
That is under Rule 97.
You reproduce Rule 97 also.
Sorry?
You reproduce Rule 97 also.
Yes, yes, yes. But one thing, Millers, Form 18 I have annexed, Millers, in this application. But unfortunately, that Form 18 doesn't bear in date. But your Lordship may kindly connect that date with with the communication that your Lordship will find, Millers, from page 40.
How much compensation you have paid?
Sorry?
Compensation is paid.
No, compensation.
also ask them to.
Well, even if that's compensation aspect is different, because even if there will be any compensation, that will be paid by occupier, Miller, always.
Has he been paid paid or not?
Paid, there's 18.
For that reason, this case urgent today, my lord.
The OP
The
number
Lordship
4
only
will, I
wanted to
think,
know
make a reply.
Yeah,
how
the
much they have paid.
idea of this act is to protect the workers.
Let's say Form 18, I have seen what they have mentioned about compensation, what your Lordship is saying now, that under the ESI Act, they have that will
Paid.
taken care of. Yes,
Paid.
that has been taken care of.
You please tell that part out.
I think OP number 4 will see, because they are the.
Please tell me that part out. Yes, next item.
101.
So I will give a submission within
Yes.
7 days.
Check up at this time. It will be adjourned interim order to continue some other.
Adjourn interim order to continue. At this time, yes.
102, I am on virtual mode, Lordship. Lordship, I am on virtual mode, and this is an application for quashing of the proceeding.
It will take little time, sir. At this time, I can't.
In 2 minutes it will take.
Any
Lordship.
small matter, Yes.
Lordship,
Any small matter.
Small matter, my lord. 109.
107, your Lordship.
Oh, 109, 109, your lord. Here, your lordship.
Small matter. 14 years back, the charge was.
Sir, your very appearance indicates that it must be a big matter.
No, very small matters, very big lawyer other side, Sangram Das. That is why.
Oh.
That matter.
Let it retain in the list, we'll see.
May I pray that your lordship fixes it of some 2 p.m. someday, convenient to your lordship.
2 p.m. are
So that
a big problem in 2 p.m.
Because it is coming after the bail matters, my lord, it is not reaching. That is.
Let it be 3. So what my plan.
Any date that is
What I'm
convenient.
thinking is, if 2 to 3 weeks, if I can get the time, then almost all the bail matters can be dealt with. Thereafter, we can hear all. So after 3 weeks, at least after 3 weeks, 2 p.m. By that time, I'll finish almost all the bail matter. Then that record goes.
Because urgency is not mine, my lord. The charge has been passed as against me. They have come.
Oh, okay. So 4 weeks में दोनों. Entry mode. Charge is against discharge you have come.
109, your lordship. There is an interim order is going on.
What is this matter?
This is matter related. This is the matter relating to maintenance, your lordship. Whether a wife living in adultery can she is entitled for the maintenance or not, number 1. And number 2, under Annex 2, the order of the JMFC, even after the going through the judgment of the MAT case, wherein the decree of divorce was passed without any relief, they passed the order of abated the maintenance, can she is entitled for the maintenance or not, number 2 point. Number 3, whether the lady himself earning something for his maintain herself, can she is entitled for the maintenance or not. 3 points my lord have to determine.
You are the husband.
I am the husband to your lordship.
You are bent up and not to pay to your wife.
Yes, your lordship. Because no. This is the
So they have
my lord.
all
No, my lord.
adultery income and everything you are bringing.
But-
Stated in trial court. After
No.
conclusion of the decision, the award has been made and 15,000 has been awarded. By virtue of the stay order, he has not paid.
No.
You have to keep on paying maintenance. Otherwise, it's a question of vagrancy. You can't.
No.
Somebody's living is affected.
Adultery.
He is not paying anything.
No, my lord.
During
How can there be a stay of maintenance, interim maintenance?
interim maintenance, your lord.
Registered, my lord.
No. ଆପଣ କହିବେ ଯଦି ଆସନ୍ତୁ, କହିସାରିଲା ପରେ ମୁଁ କହିବି। ମୁଁ ଦେଖିବି ନା ମୁଁ କଣ ଦେଇଛି। I have to show whether I.
My lord, 2011-23 order.
No. The maintenance order can't be stayed.
And under 2 year, by the way.
2011-23 order.
Let it remain in the board. We will hear it.
Minor.
We'll hear it. Let it remain in the board. Because after all, whatever, she is entitled, not, that's a different story. But maintenance of a wife, wrong, right, whatever. It is a matter of the vagrancy. She has to survive. You can't stay
No,
like
my
that.
lord. There is a specific, there is a 2 or 3 dissents.
Shall I record your statement that you will keep on giving interim maintenance?
Yes, I have given the intermittent.
Where is that?
At the time of.
Are you continuously paying every month?
No. Till the pending disposal of the met case, your lordship. Thereafter, there is a specific order.
We'll hear it.
There is a specific order that.
Yes, any.
107, your lordship.
104.
This matter, I am the wife.
Wife.
Yes.
Maintenance any price.
No. At the during till pending disposal of the met case, I paid. This is my duty here, your lordship. Thereafter, your lordship, there is a specific direction was passed that the lady is not entitled for any relief. Why I will give?
107, my lord.
104, my lord.
Sir, let us make, sir, what?
Interim order to be continued.
No, 1 minute, sir is waiting.
Waiting for their lordships to rise.
Okay, sorry.
My interim order is there, your lordship. Interim order to be
Continue. Date.
Okay, date about.
Yes, sir.
10 is minutes. There's a cancellation of bail application.
Oh, okay.
107, your
Keeping
lordship.
everybody paid.
Pardon, lordship.
Let us go systematically. Why are you? I am here. I'm not.
Pardon, lordship.
One after another. Wait.
105.
Let us have a sanity.
Lordship.
Anything. Yes.
My lords, 114, item number 114 of weekly list, lordship. That's 2021 matter, lordship. The FIR is of 2012.
What do you want?
Quashing of FIR may be taken up Tuesday, lordship.
No. You can't fix the date.
But weekly, maybe in weekly
list will be taken care of at right time.
May that item continue, lordship.
Your lordship may kindly see the order dated 20.
What do you want?
My lord, here already your lordship has passed an order that he should pay the 143 compliance. He has not done. Your lordship has passed an order that it will be dismissed without reference to the bench. It was day before yesterday. On his period, it was kept to today. That
Who is appearing?
Mr. Sanjay Das is. My lord, your lordship may kindly see order dated 24/4/24. And the last paragraph.
Yes. Subject to compliance of order urgent to counsel, it made clear that the non-compliance of the order counsel will entail dismissal of the petition without reference to the court. Yes.
So nothing is to be decided now. Your lordship has.
He should be there. He should be
It
there.
was-
Least it in the next week. The 105.
My lord, item 136. My lord, item 136, only withhold of the vital document. That is a vigilance case, your lordship. This is a vigilance case. In that only fact is the withhold of the material objects. So, your lordship may kindly.
Why so many matters are listed, Jyoti?
That is the.
Why so many matters are listed?
It's final hearing, lord.
These are specific. Specifically, bail matters. Bail matters are all there. These are the matters. Maybe some members are not allowed to these dates. Yes, extremely urgent matter can only be heard.
107.
Release of gone, my lord.
Release of gone.
My lord,
104 urgent. See, the release of gun. What will you do with gun? Are you going to kill someone? People are waiting for bail and all. You need guns. Item. See, I am telling you, extremely urgent. Try to be reasonable with the court. If extremely urgent, you tell me. Not every matter you can tell can't be taken up.
Your lordship, item
What is that?
11 and 12, my lord. My lord, in the 13th September, the petition will be.
What is the urgency? You tell me.
They are going to be retired, my lord.
Retired. Vigilance case.
Vigilance case.
No urgency.
All the matters are like.
Your lordship.
Huh? Why?
All the matters come on weekly.
Huh?
All the matters.
No. Again, it will be accumulated, na? That's the problem. Not weekly. These are miscellaneous matters. All 134 matters are miscellaneous matters. Because these people give me bond, get it listed without realizing that there is no urgency. Huh?
I beg to pardon, your lordships. Item 136, that person is bedridden since 10 years. So the final hearing of that matter, that matter is the
Final
very
hearing of what? You are convicted.
vigilance case, your lordship.
You have been convicted.
Convicted, your lordship.
So that appeal has to be heard.
Yes. Your lordship.
Appeal has to be heard. It's not so urgent.
In fact, my
Your lordship, 10 years, how, in which time you have to be gone, that is most
In fact, my lord,
You
sir,
have
10
waited
years in
for 10
bed.
years. Overnight you have urgency.
my lords, in fact,
Leaving everything, I have to hear you.
in fact, my lord, this
that
matter your
is
lordship has.
but not
Any-
In fact, my lord, this matter your lordship has heard twice and have
No,
given
no,
him
your-
time to prepare.
I know.
Yes, ma'am.
When, the regular matters are there,
Yes,
nobody was
nobody
there.
was there. No.
I was waiting after 2 o'clock, inviting people, please
Yes.
come and argue. That time nobody came. Now you want hearing.
Particular, this matter your lordship has heard twice.
Your lordship,
Twice I-
I beg to pardon that this matter, last occasion.
Anyway, forget it. Any.
1112 is not a visual matter. It's not a visual matter. The criminal case against the. Criminal case
See, an accused who has been convicted, he is going to retire, therefore that is an urgency. What are you talking? You have been convicted.
No, my lord, what happened? The sanction has not been on.
You have been convicted or not?
Hello?
Have you convicted or not?
Not convicted.
Then
Only the FIR has been registered, my lord. I have filed for the passing of the FIR, my lord. The NGT has directed by your lordship to help the stay, also stayed in the matters, my lord. On the matters, my lord. The NGT has directed to register the FIR, my lord, on the Tahsildar against the Tahsildar and the Aista Tahsildar.
so if NGT has directed, what can I do?
So, on the
FIR has to be
which the
registered.
FIR has been registered, my lord.
Registered. I can't quash it.
And my lord, it is the last.
But,
Your lordship.
Item 122, and for the complainant matter, the defense evidence has been fixed to 10 by the JMS and since January. Since January.
What do you want? What do you want?
Let it be listed on 11.
Why? You are for complainant?
Complainant, I am so losing the interest since 2016.
You are the complainant, the case is going on.
Case has been stalled.
Why?
Because of
Is there
this
a stay?
order, because of this order passed by the Honorable Coordinate Bench to adjourn for 3 weeks. It has been adjourned till 10th.
Oh,
So I pray that it may be listed in the press admission.
List after 10.
Press admission.
I pray.
May I mention?
Yes, my lord.
Why-
Saga will continue.
My lord, item number
Mention, man, what?
ଖାଲି ଆଜ୍ଞା କହିଲେ